Okay. I am here, but I am not here. Where am I? There I am. Well, let's make sure my stream is all caught up. It's moving. Okay, hi everyone. It's me, Executive Dysfunction. Welcome back to my channel. So obviously this is another stream going on about the continuing investigation of this Carina Carinosa stuff. Now I'm going to share the stream on the Facebook. Copy URL. Now let's just go on in here. Do a paste. Doop doop. Doop doop doop. Live right now. So I really tried to be more prepared this time so that I could be more on target. I'm sorry if all of that fails, but please understand that I've at least tried. Now if I can find somebody to be my ear for a moment, I need to find somebody to be an ear. Just to let me know I'm in the thing. So also, as you can see, I'm not in my normal streaming location. That is because where I would normally do this is being occupied with fun stuff, like leisurely watching television. So I'm gonna attempt to heavily disorient myself through one, trying to find the earbuds that I need, and if I can't find them, then I have to find another human. And I don't want to find another human, I want to find my earbuds. Because that's why I brought the second pair in here. There they are. I'm going to attempt to do my own sound check, but it really hurts my head when I do that. Probably gonna give myself a headache today too. So cheers to everybody doing too much when they shouldn't. I'm gonna just take a minute to say hi. How is everybody? I hope y'all are okay. Hope people have been treating you humanely and without abuse. YouTube.com. And let me see. Oh, can I see my channel? Can I click on that? Can I click on that? And it's me sitting here staring at my phone. Oh, good. Alright, I'm just gonna get the hell out of this now. So I have sound. I successfully did my own sound check. Yay! Still not a professional, not gonna be one. That's not my forte. So, as you can all see by the title here, we're going to be investigating some of the financial stuff that's going on. I wanted to know more about the bankruptcy. I'm going to minimize that window. So as you can see here, we have a folder dedicated to Ellen's Chapter 7 filing. And in the thumbnail, I believe I used this picture. Yeah, I believed I used this thumbnail just to show that this is what we're discussing today. I did a lot more reading over the past week. That's kind of why I've been a little bit gone, that and some health issues. I'm sure you all know how it goes. Life cannot always be planned out. It can be very unpredictable. Also, I put a blue streak in my hair and I am not at all shy about it. Look at me, it's pretty, I like it. Ooh, okay. Moving on from vanity. If you're new here, hi. At some point in the future, my channel is going to probably shift over to its intended purpose, which was to be for fun and sewing and some arts and crafts type things and maybe a little bit of gaming things. That is not happening right now because, in the way that life is unpredictable, my former stepmom, she was my stepmom for 20 years. I'm 38 years old. You can math out how big of a chunk of my life 20 years is at this point. It's half my life. She's passed away, and the circumstances were pretty iffy and frustrating and upsetting and concerning. So her son is looking into making sure that she has a thorough autopsy and that all of the answers are found in regards to how and why she died the way that she died. She died emaciated after being neglected in her home while living with her daughter. Her daughter had moved in. Paula, her mom, did not want her there. They tried to evict her. There was just a lot of stuff going on. I've also got I have to close my other Facebook window because it keeps sending me notifications that are going to be playing through the video. I will have to check her here. Looks like I'm getting all the notifications right now. Well, my stepbrother / Paula's son Dave is looking into things, and I am looking into things that make me curious about what's been going on with Ellen, because I haven't talked to Ellen since the split, and from what I understood, Ellen and Paula were on pretty bad terms. Paula having told me how uncomfortable she was with her daughter, the financial situation going on with her in Panama, and tension regarding Ellen's treatment, considering since the first time Paula said Ellen hit her was in 2003. All the information I have since then, I've just been getting really caught up. And in the process of just trying to see what's been going on with everybody, I started finding some things that were really curious. Like, Ellen, in the past year and a half, filed for bankruptcy, and I did not know if she filed for bankruptcy under herself, the person, or bankruptcy for her charity foundation, which you can apparently file for Chapter 7 bankruptcy for your charity. Excuse me, I did not know this. I found that out on one of the last live streams that I did. And so for this one, here we are with our thumbnail. I can close that picture out. So I've got this open for in a little bit. We're going to talk about this picture in a little bit. But right now, we're going to open that up later too. I think it's best for me to just scratch all the itchy junk on my face, because that's apparently my fate right now, to have an itchy face, and figure out where to start. So within this folder, there's more than one thing happening. Okay, there is her bankruptcy, and there's some information regarding student loans, some claims that she had made on the internet, and Some other information that I thought was interesting, since it was happening around the time that she was in court for other things. One of the things that I find particularly interesting about the American court system is how our courts don't always communicate with one another. Meaning, you can say one thing in family court and say another thing in probate court and say a different thing in civil court, and it's possible that those three things will not be checked against each other to make sure that you are submitting the same consistent information to each court. It's up to wherever you file that information for it's on the burden of the party that's opposing you to fact check, not necessarily for the courts to powwow about all of your stuff. So when I started seeing that Ellen was either being contacted regarding lawsuits or financial collection and having other things with her driver's license come up and student loans and bankruptcy and how it all's kind of intertwining and the dates that go along with her foundation, I just find it interesting. So we're here. I haven't talked like this at extended momentum for a while, so pardon me for being a little bit. So let's go with Ellen's bankruptcy file, the first filing. Now, I would like to just go ahead and tell you that I spent a good amount of time, as you can see, many of these say copy, time redacting private information like addresses, phone numbers, and social security number of the filer. So I didn't want necessarily to have everything here, even though this is part of the public court. Probate court is public. So when I opened it, it opens the PDF file automatically in a window for Firefox. Now, y'all, this is a 61-page document. 61 pages, okay? I'm gonna try to make this as easy to read as possible, but how do I hide my bookmarks? Hide. Alright, that makes it a little bit bigger. Let's zoom that in just a little bit more. Okay. Alright, we're not really losing any important information here. So as you can see, this is filed on September the 14th of 2022. This was a year ago when she filed for Chapter 7 bankruptcy. These are public documents. You can log on to the website, the Texas County Clerk, and you can request this information. This is public. You can go to Pacer and electronically request it. It is public. And I am gonna just skim through the things that I really don't understand, but I'm gonna try to highlight the things that I found interesting. And as we're getting into this, because I want to stay on point, I came with notes. I wrote all this that I thought was interesting when I was originally reading it, and I am going to have a second set of notes for the amended filing because I noticed when I was reading them that there were discrepancies, and I really want to take notes, and then compare the two. So I have two different color pens. I have everything ready to go. I'm going to try to not spend all night doing this. And we're going to read this. Now, I don't have any training in bankruptcy or finance court. I do, however, have the ability to ask Google questions when I don't understand a word, a phrase, or a scenario. So we may end up learning about stuff together. If you already work in financial court, and if you have an understanding for the documents that we're going to be going over today, please feel free to comment. If I've got something wrong, please let me know. It's okay. This is not my area of expertise. I am just researching something that I, at this point, find to be extremely interesting. And if you hang on with me while I get this one little annoying thing out of the way, we're going to find out why it is so interesting. And my kitty cat is taking a sleep right next to me. If I end up moving the camera over there so that y'all can see her, that would be great. But, you know, I bet she would detect that I was trying to give her attention and she would move. Alright, so here we go. Let's dry out my throat, drink some water, and read. This is a voluntary petition for individuals filing for bankruptcy. The bankruptcy forms use you and the debtor to refer to a debtor filing a loan. A married couple may file a bankruptcy case together called a joint case, and in joint cases, these forms use you to ask for information from both debtors. For example, if a form asks, do you own a car? Debtor 2, to distinguish between them. The answer would be yes if either debtor owns a car. When information is needed about spouses separately, the form uses debtor 1 and debtor 2 to distinguish between them. In joint cases, one of the spouses must report information as debtor 1 and the other as debtor 2. If the same person must be debtor 1 in all of the forms. Be as complete and accurate as possible. If the two married people are filing together, both are equally responsible for supplying correct information. If more space is needed, attach a separate sheet to the form. On the top of any additional pages, write your name and case number if known. Answer every question. So Ellen is filing by herself, as it seems on this file. Ellen Marie Ring. And I blocked out that number. She checks here that she does not use any business names or EIN or employment identification numbers. This is interesting. This is on her original filing. It's got, I know exactly what address this is. It is a private residence. Do not go there. Do not contact anybody there. And then she ticks off why are you choosing this district? She claims that over the last 180 days before filing the petition, she's lived in the district, so she has the ability to file for bankruptcy within the place where that address is. She's filing for Chapter 7, and she is requesting that her fee be waived. And it says here, you may request this option only if you are filing for Chapter 7. By law, a judge may, but is not required to waive your fee, and may do so only if your income is less than 150% of the official poverty line that applies to your family size, and you are unable to pay the fee in installments. If you have chosen this option, you must fill out the application to have the Chapter 7 filing fee waived, official form 103B, and file it with your petition. She declares that she had not filed for bankruptcy in the last 8 years, and that there are no cases pending on her for bankruptcy. She declines to state that she has rented her residence, which is fascinating because, this is a little aside, when Ellen was facing eviction by her mother, Ellen produced a lease to declare that Ellen was not allowed to be removed from the property, even though Paula had not written any kind of a lease and was not giving her daughter permission to rent her unit. I mean, she was asking her to get out, and Ellen just shows up with this paperwork that says that she has a lease. I can't remember who they presented it to. I would like to get a copy of that fake lease, actually, because I'm surprised that she wouldn't have offered something like that to the bankruptcy court. However, this was 1 year. The bankruptcy filing, I believe, was 1 year before Paula was trying to get her evicted. So Ellen is claiming to have lived here for at least 180 days, and then at some point has this lease drawn up that she was producing to prove that she can't be evicted from her mother's residence. So this whole no, I don't rent thing I find that fishy. But let's go on. It continues to state her name. Are you a sole proprietor of any full or part-time business? She checks no. I find this answer to be interesting because I feel that her Carina Carinosa Foundation church thing is some sort of a business, even though it is nonprofit. She's in charge of it. The foundation is her. She is the foundation. So I'm not sure if that is an answer that she can technically say no to without getting in trouble. I don't know bankruptcy law exactly, but I feel like she should have mentioned that in this original filing. The form asked if you're filing Chapter 11 under the bankruptcy code, and are you a small business debtor or as a debtor defined as the 11 U.S.C. 1182, the code. So she's saying no, she's not filing under Chapter 11. And then we go on. And it asks, do you own or have any property that possesses or is alleged to, do you own any or have any property that poses or is alleged to pose a threat of imminent and identifiable hazard to public or health safety? Well, do her drugs count? Because she said no. And, for example, do you own perishable goods or livestock that must be fed or a building that needs urgent repairs? No building that needs repairs, no livestock that needs to be fed, but she has the drugs on her, the pharmacology stuff, which we're going to get into that later. That's more into it. But she says no. And then the court is having her check off that she understands things. She's been briefed. None of that stuff applies because it's not selected. Are your debts primarily consumer debts? She says no. So I'm extremely interested at this point. 16B, are your debts primarily business debts? And she says yes. And at this point in the filing, we haven't seen any business relationship. So I'm wondering where in her mind in this original filing she had decided that she needed to decline that they were consumer debts and declare that they were business debts. Now, as she goes on to fill out the form, she declares that she is filing Chapter 7, and it asks, do you estimate that after any exempt property is excluded and administrative expenses are paid, that funds will be available to distribute to unsecured creditors? She says no. So the question is, do you estimate that after any exempt property is excluded and administrative expenses are paid, that funds will be available for distribution to unsecured creditors? I'm not entirely sure. Answering that as a no is the most accurate considering what she goes on to do in the future, but as of this filing date, I do kind of understand why she said no. because her mother was alive and she had not yet been in the car accident. So, how many creditors do you estimate that you owe? Between 1 and 49. How much do you estimate your assets to be worth? They are no more than $50,000 according to her. And how much do you estimate your liabilities to be? And she estimates they are also no more than the amount of $50,000. She signs it under penalty of perjury that the information she provided is true and correct. And she is not using an attorney. She is pro se. So, if no attorney represents me, I did not pay or agree to pay someone who is not an attorney to help me fill out this document. I have obtained and read the notice required by the statute. I request relief in accordance with Chapter or Title 11, United States Code specific in this petition. And then she signs that she understands making a false statement, concealing property, or obtaining money or property by fraud in connection with a bankruptcy case can result in fines up to $250,000 or imprisonment for up to 20 years or both. And then it cites the code. And then we continue on. We are on page 8. There is no attorney, so no attorney is signing. This goes on to explain about bankruptcy law. It allows you as an individual to represent yourself in bankruptcy court, but you should understand that many people find it extremely difficult to represent themselves successfully because bankruptcy has long-term financial and legal consequences. You're strongly urged to hire a qualified attorney. It's just warning her that she ought to, and asking her, does she really know what she's getting into? So, are you aware that filing for bankruptcy is a serious action with long-term financial and legal consequences? She says yes. Are you aware that bankruptcy fraud is a serious crime? She says yes. Understanding she could be fined or imprisoned. And did you pay or agree to pay someone who is not an attorney to help you fill out your bankruptcy forms? And she says no. And then she signs and she dates it on September 14th, 2022. And then this is from the Clerk of Court, U.S. Bankruptcy Court. It is I'm the managing attorney of Upsolve. It's a nonprofit self-service web application funded by Legal Services Corporation and leading philanthropic foundations. Our web application helps low-income debtors who cannot afford counsel generate their bankruptcy forms on their own. We are writing to notify the court that the Upsolve web application has assisted the above-captioned debtor in preparing their Chapter 7 forms. Upsolve does not provide legal advice, and Upsolve is not the debtor's attorney. And because we have provided our services at no cost, Upsolve is not a petition preparer under Section 110 of the Bankruptcy Code. As a result, Official Form 119 is not required of the debtor and has not been provided. And then if you have any questions, contact Tina. Okay, so we go on. And we are now here. Summary of your assets and liabilities. The value of what you own. So Ellen is stating that all of her property added up together should amount to about $16,405. I like how it's not an even number. I like how it sounds like she really calculated things up. And then it says, summarize your liabilities, the amount that you owe. So she is stating that her asset to debt, 16 grand versus $47,000 approximately. That's $47,073.72. I love that number. These are angel numbers to me. We're going to see more of that as we go on. You should Google angel numbers if you don't know what they are. It's used a lot in cults and esoteric woo-woo shit. Schedule 1. Your income. she claims that her income is $456. And then Schedule J, your expenses. Copy your monthly expenses from line 22C of Schedule J. And she says that her expenses are $2,070. We're going, I believe, monthly. Yes, monthly. So, are you filing? Yes. What kind of debt do you have? And then it says, once again, your debts are not primarily consumer debts. You have nothing to report on this part of the form. Check this box and submit. And she did that. And from the statement of your current monthly income, copy your total current monthly income from official form line. And then there's $2,338.83. Angel numbers. They're so perfect by being imperfect. So I don't know where this number comes from because I did not add up this form. Domestic support obligations, none. Taxes and certain other debts you owe the government, none. Claims for death or personal injury while you're intoxicated, none. Student loans, $18,000. Obligations arising out of separation agreement, none. Debts to pension, profit sharing plans, or other similar debts, none. So all of that is interesting, how she says she has no other things that she owes, but she's got $18,000 in student loans. I know a little something about that. And then we continue on. And do you own or have any legal equitable interest in any residence, building, land, or similar property? She says no. And then there's nothing else for her to fill out because she's claiming absolute destitution. Do you own, lease, or have legal or equitable interest in any vehicles, whether they are registered to you or not? Include any vehicles you own that someone else drives. If you lease a vehicle, also report it. She says no. She does not claim having ownership of any kind of a vehicle. Interesting. Let's keep going. She has nothing else to fill out. There's a lot of blank spaces you're going to see. I don't know if that's normal. Does she own any watercraft, aircraft, motorhomes, ATVs, recreational vehicles? She says no. I wouldn't know about that anyway. And do you own this? And there's nothing to write there. And now it asks what her personal property is. And this is probably where we got that number up there at the top. So we're going for, current value of any portion of what you own for property. So she's claiming she has a bedding and a sofa at $18,000. Okay, it must be really expensive stuff. Our couch is a U-shaped sectional. It's one of the really luxury ones. We bought it in California where everything's expensive for less than $1,000. So I don't know how much her sheets cost or her bed frame, but $18,000 or $1,800. Okay, so $1,800 for bedding and a sofa. For her computer and her cell phone, those are worth to her $4,000. You know, my laptop didn't even cost $700. That's interesting. And then she goes on to claim she has $4,700 worth of books, geology, paleontology collections. I would like to know what that is. She says she has a $1,500 guitar. She declines to disclose any firearms, even though they exist in her mother's home. And clothing, she claims $900 worth of clothes. She declines to claim any jewelry. She declines to claim any animals. And she also declines any other personal household items that she did not list, including health aids. And add the dollar value of all your entries from part 3. And so she's saying that all of her stuff together is worth close to $1,300. So does that add up with the number here? She said she had assets worth $16,000. And she was claiming $13,000 for her personal property, almost. So I wonder where the other comes from. I guess we'll find out. $5 in cash on the day she filled out the form. I guess she had to put something because she felt like doing it. Deposits of money for checking, savings, or credit unions and things. She says no, she doesn't have any. Bonds, mutual funds, traded stocks, she says no. Non-publicly traded stock interest in incorporated or unincorporated businesses, including an interest in an LLC partnership and joint venture. She says no, however, I find that contradictory. But we'll move on. Government and corporate bonds, no other negotiables, no. A retirement or pension account, she says no. Security deposits and prepayment, she says no. Annuity, she says no. Interest in an education IRA, an account in a qualifiable ABLE program or underqualified state tuition program, she says no. Trust equitable for future interest in property other than anything listed in line 1, in rights or powers exercisable for your benefit, she says no. Patents, copyrights, trademarks, trade secrets, and other intellectual property, she says no. Licenses, franchises, and other general tangibles, she says no to that. That I find contradictory. But we'll move on. Tax refunds awarded to you. She claims an $1,800 federal tax refund. She says no family support is provided. And then she claims that she received a CARES stimulus check for $1,700. She says it is other amounts someone owes you. So this would be unpaid to her. I believe she is stating that she is owed $1,700 in CARE Act stimulus check. So I'm really not sure what the status of that is. Interest in personal insurance policy, she says no. So she's not claiming that anybody has her listed as a beneficiary under their insurance. Any interest in property that is due to you from someone who has died, she claims no, which is extremely important because she is later trying to state that her mom has left her money and property, which her mother left no will. She goes on to claim no to claims against third parties, whether or not you have filed a lawsuit or made a demand for payment, which at the time I understand that she couldn't file a lawsuit for the car accident because it hadn't yet happened, but we don't know if there's anything else that she had under her belt. Other contingent and unliquidated claims of every nature, including counterclaims of debtor in rights to set off claims, she answered no. Any financial assets you did not already list, she answered no. Add the dollar value of all your entries, that's $3,500 approximately, but look, it's not just straight $3,500, it's $3,505. She loves to make those numbers work. So, you're missing the joke that's constantly rolling in my head that we're going to get to, that Ellen self-admittedly did not keep records. So how her numbers can be so precise is hilarious to me. So then we go on to, do you own or have any legal, equitable business interest in any business-related property? She says no. And then goes on to have nothing to fill in for a bit. Do you own or have any legal or equitable interest in any farm or commercial fishing? She says no. A bunch of stuff that doesn't apply to her, so we skip that. Do you have any other property of any other kind you did not already list? Season tickets, country club membership? She says no. And then we go on to list totals in each part of the form. She lists 0 For vehicles, personal and household items, 12,900, financial assets being the 3505, and then that brings it up to the 16,405. I love how precise that is. And so then we move on. Schedule C, the property you claim as exempt. So which exemption are you claiming? Check 1 only, even if your spouse is filing with you. She is claiming federal exemptions. So for each item you claim exempt, you must specify the amount of the exemption you claim. One way of doing that is to state a specific dollar amount as exempt. Alternatively, you may claim the full fair market value of the property being exempted up to the amount of any applicable statutory limit. Some exemptions, such as those for health aids, rights to receive certain benefits, and tax-exempt retirement funds, may be unlimited in dollar amount. However, if you claim an exemption of 100% of fair market value under a law that limits the exemption to a particular dollar amount, and the value of property is determined to exceed that amount, your exemption would be limited to the applicable statutory amount. So there's a cap on it. If you have something that you're saying is worth $8,000, but the Kelly Blue Book value for it is $2,000, they're going to stop you at $2,000. You can't claim any more than that. Just like if you were saying that you had a car or something, but that's an example. So she's claiming federal exemptions for any property that you list on Schedule A/B that you claim is exempt. Fill in the form below. So she's trying to have exempt household bedding, $1,200. Household sofa, $600. Fantastic. Current value of the portion that you own. So her bedding is what's expensive, her sofa is what's cheap, and her electronics computer, the $3,400. So if that's just a fraction of fair market value, I would like to know, I insist on knowing, how much is that computer worth? I really need somebody to tell me what kind of a computer she's got, what brand is it, how is it built, what is that processing speed, what are those video audio cards, like what makes that computer worth $3,400? Because I know gaming computers that are a couple grand, but that's like when they're new. So I need to know, like, what kind of, is this a NASA computer? Is this special? Does this thing fly drones for NASA? What's happening to this $3,400 electronics collection, unless she's trying to list more than just a computer and a cell phone? There could be a TV involved, so laptop, $1,200 for a good one. TV, $1,200 for a good one. Yeah, okay, I could see how things add up. $800 for a good phone. But she didn't list a TV or anything. She listed a computer and a phone. Moving on. Are you claiming a homestead exemption? No. Electronics cell phone, $600. Oh, okay, so now she's splitting it up. Electronics computer, electronics cell phone, book, a $3,500 book. Y'all, she is trying to have an exemption for a $3,500 book. And she doesn't bother to tell us what the title of the book is. What makes that book worth $3,500? These collectibles in geology, paleontology, $1,200. Where I'm going to need to know more about these items. This $1,500 guitar. There's expensive guitars out there. We could look that up, but I'm not going to. $900 worth of clothes, that's self-explanatory. The $5 in cash and the tax refund. So she's trying to have all of these things exempt. Everything that she has, obviously, she wants to be exempt. So, do any creditors have claims secured by your property? Check no. She checked no. List all secured claims. There's nothing here. Moving on to Scheduled E/F creditors who have unsecured claims. Do creditors have priority unsecured claims against you? She says no. So go to part 2. Scroll down. Do any creditors have non-priority unsecured claims against you? And then she says yes. And this is where we start getting into fun things. So I would just like to stop and look at my notes. So we looked at her household expenses, her asset list, the $3,500 book, the collectibles that she says she has, the guitar that she's got, and there is no mention of the value of her children's belongings. So there's no discussion of the infant crib, cradle, car seat, necessary audio and physical toy stimulant for children who are learning for teething, no books for the kid, clothes, none of these child expenses, child furniture, bedding is listed on her assets, which I find interesting. She's now going on to list the things that companies or collectors claim that she owes, and I find it extremely fascinating. So it's where it starts isn't the beginning. The beginning is actually at the end, and I'm just going to give you a little spoiler. In 2004, she racked up a student loan debt for $18,000 with TSTC. She misappropriated those funds by not actually going to school. She spent the money. She did not graduate. So I don't believe she qualifies for any loan dismissal in any student loan forgiveness program because she misappropriated the funds. It is an outright theft because she did not get an education. But we're starting at the top with August 1st, 2014, Bank of America. The last 4 digits of the account number, I only care about the one. It ends in 3. And it's a credit card, and it's for $465. I see she started small. And then Bank of America, here we are again. We have a new account this time. It ends in the number 8. June 4th, 2015, $1,500.23 of credit card. Bank of America, once again, approximately another year later. September 19th, 2016, bank account ending in 8, but this time it's different. So the last 4 of that other one started with 2, and the last 4 of this one started with 6. So, and this one has increased yet again to $2,757. So, 465, 1,523, 2757. It just keeps getting up. So Bank of America obviously has not figured out they should not let Ellen get an account with them. They did not learn their lesson. 3 years in a row, Bank of America got bit. So they're wanting their money back. And then she lists, and now these are not necessarily going to be listed in chronological order as I stated. Barclays Bank Delaware. I don't know what Barclays Bank Delaware is, but it specifies it is a credit card that the debt was incurred September 24th, 2019. She loves September. This time the amount was for $6,155. And then we go back to 2015. So while she was hosing Bank of America, she was simultaneously ripping off Capital One for the tune of $1,725, which she did not pay on a credit card. It says the debt was incurred June 20th, 2015. So Capital One and Bank of America, both in the same year, were trying to get their money back from her. In 2019, once again, not just Barclays Bank of Delaware, but she is now at Citicards Bank, running up another credit card for $7,177 in October 6th of 2019. So she's just racking up credit card debt. Then Credence Resource it's probably management. This is a collection agency. The debt, it says, incurred in April, and it's $402. So it's Discover Bank again in 2015. So that's 3 banks in 2015. Discover Bank, Citicards. Oh, I know. Discover Bank, Capital One, and Bank of America. All 2015. Ellen's running up debts, so that's $1,510. Y'all, I just want to count it up. In 2015 alone, how much money did she run up? So, 2A15, we have 1510. And then 2015 again. 2015, we have 1725. And then let's go back up here to Bank of America. 6/4/15. Oh, those were both the same month. June was a busy month. 2015 was a busy year. 1, 5, 2, 3. So then we go back down to Discover Bank where we were. Let's just make sure we get everything together. And then LCA Vision Incorporated, this medical debt for LASIK eye surgery. Excuse me. In July of 2022, just before she filed for her bankruptcy. So in 2022, she racked up a couple of debts. In 2019, she racked up a couple of debts from Citibank. That was a big one. And USA Savings Bank, that was a pretty big one too. So, all right, I'm moving all around. All right, so back where we were. LCA Vision. It's 2022, and then 2021 for Rent Debt Automated Collection or Collective. It's a collection agency. They want almost $3,500 from her. So she's got collection agency, and then another collection agency, Synchrony Bank Care Credit. That's for $493. And then USAA back in 2019. I'm wondering how she got the USAA savings. But you can actually apply for a credit card without being a member there. I forget about that. So then she racked up almost $2,000 debt with the USAA Savings credit card in 2019. And then the big one back in 2004 for unknown. It's from Harlingen, and it was for $18,000. It says the debt was incurred July 1st, 2004. So we know how far back she's been, at least on known record, dodging payment. There has been no mention of the $33,000 that she took out in my dad's name. And then here it goes down to list student loan debt as $18,000, and then all debt together, $47,000. And those are her debts. And now I'm going to add up all these 2015 charges. So that's 8, 4, 5, 10, 17. Wow. So in 2015 alone, between the different banks, between the different credit cards, she amassed $4,758 in debt. So, I mean, if you're sitting where I'm sitting, you can see the value in companies maybe talking to each other a little bit more. But I don't understand how banks do their stuff, you know. So let's go on to executory contracts and unexpired leases. Do you have any of them? She says no, because she's denying having a lease with anyone. Co-debtors, she's claiming to have no co-debtors. Within the last 8 years, have you lived in a community property, state, or territory? It says yes. Did your spouse, former spouses, or legal equivalent live with you at the time? It says no. And then this is a really confusing thing for me because I don't know if she's counting Panama and I don't even know how she's answering this question. I don't understand this question. Like, even I'll admit some of this stuff. If you don't know how to fill out these forms, yeah, this shit is going to be confusing. But if you're me, you triple read stuff before you submit it. So we continue. It says not employed. Describe employment. Ellen selects not employed. This is important. And then it says monthly wages, 0, nothing but zeros for indicate whether you have the payroll deductions below. So, nothing. For retirement, or taxes, insurance, domestic support, union dues, nothing. No interest, no dividends, no social security. And then it says that she receives SNAP benefits in the amount of $456. Do you expect an increase or decrease within the year after you file this form? She selects no, and then moves on to your expenses. Is this a joint case? The answer is no. She fills out the information for herself and her dependent child at the time her son's 3 months old, and then she goes on to list expenses. Rental or home ownership expenses for your residence include first mortgage payments, any rent for the ground or lot, real estate taxes, property, homeowners, maintenance, repair, upkeep, association, condominium dues. Now, since I know the private residence and I know how the household worked, I know what bills were in whose name, because it was her mother's house. So the electricity and gas would have been in her mother's name, mortgage payment in her mother's name, water, sewer, gas in her mother's name. The internet would have been in her mother's name as well. Now, Ellen would have had her own cell phone, which a cell phone bill could be $140. I do believe that. Other specify, there is a 0 there. Food and housekeeping supplies. She says it's about $400 a month for her to eat and keep up with the house, and then $150 a month in childcare and education. Clothing, laundry, and dry cleaning, she estimates is $120 on monthly expenses. I don't spend $120 a month in frickin' laundry soap. Hell, I don't think I spent $20 a month on laundry soap. Anyway, Personal care products and services, she lists at, I believe, 10, that's 250. Medical and dental expenses, she listed at 250. Transportation, like we're halfway through this, we're getting through it, we're powering through. Medical and dental expenses, transportation, she's including her driving expenses. So that would have to be gas. I'm guessing 160 a month in gas. Whatever. Entertainment, clubs, recreation, newspaper, magazines, and books, $100 a month. Charitable contributions and religious donations. She's saying that she's delivering $40 a month in charity while she's destitute. Okay, fine. Insurance, she claims no life insurance, no health insurance, but she has vehicle insurance. Yet she listed no ownership or responsibility for a vehicle, but we're still getting to that. She doesn't have anything listed for her taxes, car payments, alimony, nothing about mortgage, property ownership, bunch of zeros. She does claim that she pays for a storage unit. I believe that's $140 a month. Calculate your monthly expenses. She states that she is spending approximately $2,070 a month while only receiving SNAP benefits of $456 a month. Make it make sense. Especially considering the majority of these debts are from before the 2021-2022 time frame. She does have some large ones in 2019, and we saw that, but she's not racking up a year's worth of living expenses on these credit cards immediately in 2021 and 2022, which we would see reflected in this bank account. Ask me how I know. I'm not a bankruptcy expert, but I do understand a little bit about paying bills and having proof that you've paid your bills, proof of your living expenses. So, alright. We're going to go on to say that her monthly expenses, her net income is negative $1,614. That's her claim. And then do you expect an increase or decrease in your expenses within the year? She says yes. Her explanation is due to childcare. Humans are expensive. That is absolute truth. They only get more expensive. So then she goes on to say that she didn't pay an attorney or anybody to help her fill out her forms. And then statement of financial affairs. She's stating that she's not married. It does not give a widow option. During the last 3 years, have you lived anywhere other than you live now? She listed a past address where she claims she lived there from 2017 until 2021. I know that Ellen was bouncing back and forth in and out of her mom's in Austin, depending on the emotional climate between her and her mother. Then she says, within the last years, did you ever live with a spouse or legal equivalent in a community property, state, or territory? She says no. I wouldn't know the correct answer to that anyway. Do you have income from employment or from operating a business during this year or the 2 previous calendar years? She says no, which we'll get to that. Again, from January 1 of your current year until the date you filed for bankruptcy, 0 wages, 2021, 0 wages, 2020, 0 wages. She should have way more credit card debt from those years if she's claiming that she's got all these living expenses and she's not paying for them. So then here we get into, did you receive any other income during this year or the 2 previous calendar years? Include income regardless of whether the income is taxable. Some examples could include alimony, child support, social security, unemployment, other public benefits, pensions, lawsuits, royalties, gambling, lottery winnings, etc. So she is claiming, yes, residuals to the tune of, and I wrote this down because I thought this was interesting, $11,852, and then her yearly SNAP benefit collection was $2,871, and then for 2021 she's claiming that she made $12,432 in residuals, whatever residuals means. Remember, she's claiming absolutely no assets, no business, nothing. What is this residual coming from? We don't know. It's not given to us. So then the calendar before that, pandemic something assistance, $10,500. So in 2020, for some reason, she received $10,000 from the government for pandemic relief. But she's claiming no assets of any kind, no ownership of anything. So here are the debtors, primarily consumer debts. No. Are either debtor 1 or debtor 2's debts primarily consumer debts? And it says no, neither debtor 1 nor debtor 2 has primary consumer debts. So if none of the debts were for her living expenses, who's been helping her with her living expenses? And what exactly did these debts go to? What were they buying? So she says no. Nothing else to fill out. Scroll down. Within a year before you file for bankruptcy, did you make a payment on a debt that you owed anyone who was an insider? Insiders include your relatives, any general partner's relatives, or any general partner's partnerships with which you are a general partner, corporations of which you are an officer, director, or person in control or owner of 20% more of the voting securities, and any managing agent, including one for a business you operate as a sole proprietor. Include payments for domestic support obligations, such as child support alimony. So she's saying that within the year of filing bankruptcy, she did not pay anything that she owed anybody, including to relatives. So she's denying paying any living expenses at her mother's house. And I know that her mom probably bought half the food there, because that's how it was when I was there. She provided everything. Paula did everything for us. Within 1 year before you file for bankruptcy, did you make any payments or transfer any property on account of a debt that benefited an insider? And she says no. So she's denying involvement and access to everything. It's wild. Oh, he's laughing. Okay. Within 1 year before you file for bankruptcy, were you a party in any lawsuit, court action, or administrative proceeding? And the answer to this was yes. So here we have Citibank suing Ellen for $7,000, which I don't believe she listed in her... Maybe that was listed in the debts up there. And then she was also the plaintiff in a lawsuit for a paternity test. Now, I redacted the name of the person she was suing because, one, I have no idea what the status of that is, but I do believe it was concluded and this person is not a public figure, and I don't believe they were, in fact, the father. So, and if they were, it's actually, if they were, it does matter. Your child's in trouble. Look at the mother. So, if anybody is the father to this kid, please, for the love of God, step up. Within 90 days before you filed bankruptcy, did any creditor, including a bank or financial institution, set off any amounts from your accounts or refused to make payment because you owed a debt? She answered no. I have no idea if that would be true. Within a year before you filed bankruptcy, was any of your property in the possession of an assignee? I don't even know how she should answer that with the car being the state that it's in, but we're getting closer to the car. Within 2 years before you filed bankruptcy, did you give any gifts with a total value of more than $600 per person? She says no. And that means her charity value is limited to less than $600 a person. Within 2 years before you filed for bankruptcy, did you give any gifts or contributions with a total value of more than $600 to any charity? She says no. So that means she hasn't given any more than $600 to a charity. I find that fascinating as well. Within 1 year before you filed for bankruptcy, or since you filed for bankruptcy, did you lose anything because of theft, fire, or other disaster, or gambling? She says no. Certain payments or transfers within 1 year before you filed bankruptcy, did you or anyone else acting on your behalf pay or transfer any property to anyone you consulted about seeking bankruptcy? She answers no. So, Ellen has nothing and no one, and apparently manifests money out of thin air and creates debt. Like, I don't even know how she keeps getting credit cards. Within 1 year before you filed for bankruptcy, did you or anyone else acting on your behalf pay or transfer any property to anyone who promised to help you deal with your creditors or to make payments to your creditors? The answer is no. Now, we wouldn't know that because what if Paula was helping Ellen and Ellen lied? We don't know that. Paula's dead now, so we can't ask her. And I do remember Paula used to pay off Ellen's financial debts. That's one of the things she was doing with the college loan. Within 2 years before you filed for bankruptcy, did you sell, trade, or otherwise transfer any property to anyone other than property transferred in the ordinary course of business or financial affairs? And she says no. So she's saying that she doesn't have anything, never had anything. Well, maybe not never, but like none in the last 2 years, she's saying. Within 10 years before you filed, did you transfer any property or self-settled trust similar device of which you're a beneficiary? And she's saying no. So Ellen, once again, says no. Within a year, any financial accounts or instruments held in your name for your benefit closed, sold, moved, or transferred? And she's saying no. This includes checking, savings, money market, or other financial accounts, shares, banks. And see, this is a sketchy answer. She says no, but we know that everything in the Carina Carinosa Foundation was Ellen's. But once again, do you now have, or did you have within a year before you filed for bankruptcy, any safe deposit box or other depository securities, cash, or valuables? And she's saying no to that. Have you ever stored property in a storage unit or place other than your home within a year before you filed bankruptcy? She says no. So I wonder when she opened that U-Haul unit. And then here we go. Do you hold or control any property that someone else owns? Include any property you borrowed from, or storing for, or hold in trust for someone? And she says yes. A car, a 2010 Toyota Yaris donated to the 501c3 public charity, valued at $1,400. Ellen is in possession of it. Now, she would be saying that Ellen does not own the car, that the charity owns the car, but Ellen is the president and founder of the charity, so technically Ellen owns the car. But this guy, we've seen his name before, and now I understand why his name keeps coming up. So he's also in another document. Environmental, for the purpose of Part 10, the following definitions apply. Environmental law means, alright, we don't have to worry about the hazard waste stuff, unless the drugs are in some way a thing. We don't need to worry about the environmental law section. There is nothing filled out. There's nothing to look into. Within 2 years before you filed for bankruptcy, did you give a financial statement to anyone about your business? Include all financial institutions, creditors, and other parties? She answered no. I don't know if I believe that, but she said no. And then she signed it. And she's swearing under penalty of perjury that everything is true and attaching additional pages, and no, she didn't pay anyone to help her. Overflow statement of financial affairs. This is what Ellen's saying. These are Ellen's words, okay? Ellen does not have an attorney. Ellen is saying this stuff to the court. Case title, Land Tower Tech Ridge versus Ellen Ring. I want to look that up later. The case number, she says, there isn't one, but I could send the final bill, which has probably gone onto my credit report. Now, if there's a case title, there's a case number. Title number. Anyway, nature of the case. And this is where Ellen's savvy legalese speak comes into play. And now let's see, what does Ellen say to persuade the court? The apartment complex where I was living lied every step of the way in my final year there. Instead of improving the maintenance and valuing residents, they began hassling anyone who protested their lazy misadministration. I had to use a free legal aid service, and they still stiffed me with a bill for $3,453.84. I refused to pay this for several reasons. One, it lies and says that they had to replace the sliding glass door. Totally false. 2, it falsely holds me accountable for the automatic door locking system not functioning properly, which was a fault of maintenance. 3, it lies and says that the repainting fee was $750. The garages did not take 40 hours to redo, and the inside was to be free after living there 5 years. For the admin whom I got tired for being so rude to the residents, fired. The admin whom I got fired for being so rude to the residents falsified documents trying to evict me on fake charges multiple times. The law firm went to battle for me. In the end, they raised my rent from $1,500 to $2,500 to finally get me to leave. Yes! 5, they did not succeed in evicting me, yet their final paperwork says so. I did my part and left the apartment as clean as one would expect after 5 years. There's no way I'm paying that bill after they lied to the tune of several $1,000s, refused to renew my lease, where they could have been paid 6 months in advance, and I was 4 months pregnant. I even had to request the final bill because they didn't create it after I left. Fantastic. Now we have a timeline. At 4 months pregnant, she was evicted. And that's when she turned up on her mom's doorstep. 4 months pregnant, evicted. Land Tower, Tech, Ridge, B, Ellen, Ring. And since I know how to find out where that was, she's trying to say the address is unknown. However, she lived there for 5 years. And it was the last address she had before she ended up at her mother's house in Harlingen, so she definitely knows where the property is. Refusing to disclose that information is extremely silly. She then goes on to submit statement of intention for individuals filing. You must fill out this form if creditors have claims secured by your property, or if you've leased personal property and the lease is unexpired, blah, blah, blah. She has submitted nothing for that page, nothing for the next page. Absolutely no lease agreement. And then she signed it. Same day as all the others, September 14th, 2022. And then we go on, statement of your monthly income, not married, doesn't say widowed. And then gross wage, salary, tips, commissions, everything 0. And then interest, dividends, and royalties, $1,975.33, a perfect angel number. Excuse me. So this is the monthly income that she receives from all sources during the full 6 months before you file this bankruptcy. So yeah, she's saying that she makes nothing and then she gets SNAP benefits. Calculate your total monthly income. And then she says she gets $2,338.83 in income, while stating in other parts of this form that she receives no income. So, as you can expect, there was a response to this, and we have it. But I've been reading for an hour and 20 minutes. So next, calculate your income times 12, your annual income. So she is estimating that she makes 28 grand a year in whatever these residuals are that she didn't list the source for. And then the median income for your state and size of household, which she's listing herself as a single mother, she's claiming is $74,636. I don't know what the actual median family income for a single mother with one child is, but that's what she's claiming it is. How do the lines compare? Line 12B is less than or equal to. So she's saying that she makes less than the median income, and then she signed that on the same day in September under penalty of perjury. And then in the United States Bankruptcy Court, the above named debtor hereby verifies the attached list of creditors is true. And then it is the list of people she owes money to. Bank of America, Barclays Bank, Capital One, Citi Cards, Credence Resource, Discover Bank, LCA Visions, Rent Debt Synchrony Unknown, USAA Savings Bank. And that is her original filing for bankruptcy. And I took notes, and my God, did I have some questions. But before I could even finish reading it, because this already existed, there was a response. And so I believe this is the complaint. So let's go ahead and open that up. And we're gonna whisk it over here because it opened up in the wrong screen again. And this is the complaint from the United States Department of Justice, Office of United States Trustee Kevin M. Epstein, United States Trustee Aubrey L. Thomas, Assistant United States Trustee Andrew Jimenez, Trial Attorney Corpus Christi, Texas Bankruptcy Court for the Southern District of Texas, Brownsville Division, case number, plaintiff, Ellen, all of this stuff. So here we are, everybody knows who everybody is. Complaint objecting to discharge of L. Marie Ring to the Honorable Eduardo V. Rodriguez, Chief United States Bankruptcy Judge. So Kevin Epstein, I believe, is the one who's typing this up, or it is the Office of Kevin Epstein. He is the name. He's the name on the door for this one. So, through the undersigned counsel, and respectfully represents and alleges as follows. The court has jurisdiction over this adversary proceeding. It is all of this information right here is stating that they're just following the order of justice. They're following the rules. Defendant Ellen is an individual who filed for voluntary petition on September 14th for Chapter 7. They then go on to state that defendant is also known as Carina Carinosa, which she failed to mention in her original filing. This is something that, if you've been following the case, or if you know about Ellen personally, you understand that she has been going under Carina Carinosa since about 2012. That's as far back as I can trace her using the name. So, allegations, general allegations. On September 12th, 2022, defendant filed pro se a voluntary petition under Chapter 7 commencing the case number. Defendant signed the voluntary petition declaring under penalty of perjury that the information in the petition was true and correct. On that same date, the defendant filed her schedules and statement of financial affairs, the SOFA, as they will call it. Before filing the schedules, defendant signed the declaration concerning debtors' schedules under penalty of perjury, declaring the schedules are true and correct. Before filing the SOFA, defendant signed the SOFA under penalty of perjury, declaring she had read the answers. And so it goes on to state that everything Ellen signed under penalty of perjury. As I was saying as I read it, it's saying, before filing this, she read it, she understood, she signed. She filed an amended voluntary petition on December 21st. Well, okay, before filing the fee waiver application, defendant signed the fee waiver application under penalty of perjury, claiming the information was accurate, and then on November 14th, 2022, the court entered an order granting the fee waiver application. The defendant filed an amended voluntary petition, amended schedules, on December 21st, which I should probably read that amended one first, but I like this. We're gonna jump around and I'm gonna read this. Before filing December 21st, amended voluntary petition, defendant signed the amended, declaring it was true and correct, amended schedules, signed declaring, before filing the SOFA, on the 21st, everything true and correct. The meeting of creditors was originally scheduled for October 28th. Defendant testified under oath at that meeting. And it just goes on. And it says everything she did under oath, and she testified, she signed, blah, blah, blah. Allegations regarding the Carina Carinosa Foundation. Plaintiff alleges, and that would be Epstein, plaintiff alleges that defendant formed the Carina Carinosa Foundation as the foundation in 2017 as a Texas nonprofit corporation. Plaintiff alleges that defendant is the director of the foundation. Plaintiff alleges that defendant conducts numerous business activities through the foundation, including the sale of books, nutritional supplements, spiritual healing sessions, and audiovisual media. As we've been seeing through Ellen's YouTube website, the app that she developed, etc., she has claimed all of these things. So, as the plaintiff is alleging the things that we have seen on the internet, this is going in the court document. Plaintiff alleges the defendant is the only person who works for and provides services to the public through the foundation in the United States. In her schedules, defendant does not disclose a personal bank account. Defendant utilizes the foundation's bank account to pay her living expenses. Plaintiff alleges that defendant has an employment agreement with the foundation in which she is compensated for the services she provides through the foundation. Now, this is like, did you catch that with me? The defendant alleges that she has an employment agreement with the foundation that compensates her for the services she provides. She is the foundation. Ellen is essentially giving herself. Do you see what I mean? As she is the sole, she's president. So, plaintiff alleges that defendant failed to provide information, including books, documents, records, and papers that explain her financial condition and the business activities executed through the foundation. Plaintiff alleges that although the foundation was formed as a nonprofit corporation, the only income earned by the foundation is for products and services provided by the defendant, and the primary expenses of the foundation are the personal expenses of the defendant. That's Did you catch that? The plaintiff is alleging that Ellen's personal expenses are being covered by the foundation because the foundation is her personal interest. It's the only income she gets. So hand in hand, pot, hand in pot, hand all up in pot, just all the hands in the pot. You see? Just she lives in the pot. Foundation appears to have ownership interests in or conducts businesses as Powerful Energetic Medicines, Magic Money Miracles LLC, the Native American Church of Peace, Freedom Equity Lenders Real Estate, and then in addition the Carina Carinosa Foundation. But that is the umbrella that all of this is operating under, right? Okay, so, and this is great because I found all of this myself before I even got access to this document. So, good job. Plaintiff alleges that these are additional businesses created by defendant to earn money for her own personal expenses through the foundation, which, working for a living seems to be the theme here. But through the foundation, if you're the only person running it and the only person collecting money off of it, it's a very I don't know what the word is. If you know the word, please comment. So, in her defendant's failure to accurately disclose her income, defendant failed to fully and accurately disclose her income from the foundation and its related businesses in the schedules and SOFA in her original Schedule 1. Defendant listed her income as solely $456 in SNAP benefits. She falsely claimed her income from employment or operating a business was $0. So, as the owner-operator of this foundation, how do you make $0 when your foundation has money? I have the same questions. In her original SOFA, defendant answered no to question 4, which asked, did you have any income from employment or from operating a business during this year or the 2 previous calendar years? Defendant further stated $0 for 2020, 21, and 22. That was for her gross income. So it goes on to state, question 5 of the SOFA asked, did you receive any other income during this year or the 2 previous years? Defendant answered in her original SOFA that she received $10,500. The source of income is illegible. During 2020, $12,432 from residuals and $1,305 from SNAP during 2021. And then it lists the residuals and SNAP again for the other years. And it says that defendant filed amendment schedules and continue to understate her income. Defendant failed to provide information and documents to support changes in income stated in amended schedules and amended SOFA. Defendant falsely states in her amended Schedule 1 that in addition to her SNAP benefits that she has gross monthly income of $611.13 as the Minister Program Director of the Foundation. Docket number 29, pages 31 to 32. Upon information and belief, defendant's gross monthly income from the foundation is at least 4 times the amount she listed on Schedule 1. Despite having paid herself under the employment agreement with the foundation on defendant's amended SOFA, defendant did not correct her answer to question 4 and maintains that she had no income whatsoever in the 3 years, 2020-2022, from business activities. Defendant changed her answer to question 5 of the SOFA to reduce the amount of income received from other sources. Specifically, defendant states she receives $1,094.04 from memberships and $10,500 from emergency aid during 2020, $8,766 from memberships, and $1,035 from SNAP benefits in 2021. And, we'll read those when we go over the amended one. So it's saying that she failed. It's saying what she wrote down, and then the things that she continued to fail disclosing. Based on the bank account statements for the foundation, defendant statements regarding her income and her schedules and SOFA are false. Allegations regarding court filing fee waiver. In the fee waiver application, defendant asserted that her sole source of income is SNAP benefits. And in the fee waiver application, she further asserted, I do not earn enough money each month to cover my basic expenses. Upon information and belief, during the 9-month period prior to filing her bankruptcy petition, defendant received average monthly income of approximately $2,800 from the foundation. Specifically, plaintiff alleges, upon information and belief, that defendant used funds in the foundation's bank account to pay her personal expenses. Defendant did not disclose those funds as part of her income or assets for the court to consider in whether or not to grant the fee waiver application. So now she's got her mom covering household expenses, and she's using the foundation and not disclosing that the foundation is covering her expenses. And they're catching it. They're catching all of it. Upon information and belief on the petition date, the foundation held approximately $1,142 in funds that the defendant could have utilized to pay her court filing fee. Plaintiff alleges that as of the petition date, 150% of the HHS property guidelines for 2022 was $2,289. Plaintiff alleges, upon information and belief, that defendant's income exceeded the amount to qualify for a waiver of the court filing fee. So they're trying to get her for the filing fee too, not just for the stuff that she's not disclosing because she ain't disclosed it. The plaintiff alleges that in her fee waiver, defendant made false oaths and failed to disclose all of her income and assets, including her alleged inability to pay the court filing fee. Plaintiff is informed... You need to lean back, sorry. Plaintiff is informed and believes thereon alleges that defendant, prior to and after the filing of the bankruptcy petition, used the bank account of the foundation to pay for her personal expenses. So they are saying that not only did she fail to disclose that the foundation was covering expenses, but that she was going to continue to use the foundation to cover expenses. So does this mean she didn't file bankruptcy for her foundation? That she only filed it for herself and that the foundation still exists? I'm not sure. But moving on. So the defendant asserted she did not own checking, savings, or the financial accounts. She asserted she does not have or own any legal or equitable interest in any business-related property. She asserted she doesn't hold or control any property that someone else owns, which failing to include her mother's property was a big mistake, I believe. When asked during her testimony at the Rule 2004 examination how she managed her affairs without a bank account, defendant answered that the foundation has a bank account. She further testified that she used the foundation's bank account for personal expenses. When asked who the authorized person is to make transactions with the foundation's bank account, defendant testifies, the signatory power is with me. She further testified that nobody else is authorized to make transactions with the foundation's account. How damning is that? When asked at the February 24th meeting of creditors if all her assets were disclosed in the amended schedules, defendant testified that all her assets were disclosed and she did not anticipate the need to further amend schedules. Plaintiff alleges that defendant repeatedly made false oaths or accounts in the SOFA and schedules and amendments thereto regarding property of the foundation under her control in which she uses for her personal benefit. And you know, this is exactly what I've been suspecting. Failure to disclose interest in business is defendant failed to fully and accurately disclose her interest in businesses in the schedules and SOFA. On question 19, she asserted she has an interest in Magic Money Miracles with 0% of ownership valued at $0. Defendant did not disclose any other incorporated or unincorporated businesses. Defendant asserted that within 4 years before the filing of the bankruptcy, she did not own a business or have connection to any business. Plaintiff alleges the defendant has an interest in the foundation as its director, which she absolutely does, which she has failed to disclose in the SOFA. Plaintiff alleges that defendant is also a member, partner, officer, director, or is sole proprietor of the Native American Church of Peace, Powerful Energetic Medicines, Freedom Equity Lenders, Austin Secret Spa, and Goddess Carina OnlyFans account, and they are absolutely correct. Well, I think Freedom Equity Lenders, she might have somebody involved. The other ones, she's vice president of the Native American Church of Peace, according to her LinkedIn. So who's the president? Anyway, plaintiff alleges upon information and belief that defendant failed to disclose her interest in these entities and income generated therefrom. Plaintiff alleges that defendant repeatedly made false oaths or accounts of her interest in businesses as petitioned with the date. So, allegations regarding other financial accounts and transfers. When asked during her testimony at the rolled examination if the foundation receives payments through electronic payment platforms, defendant testified, yes, we have PayPal, Venmo, and Cash App account. Defendant further testified that she is the person authorized to make transfers from the Venmo and Cash App accounts to the bank account of the foundation. So Ellen has control of everything. When asked during her testimony about the transactions reported in the wage and income transcript of the IRS for 2021, defendant answered that the transactions in the transcript are related to a Cash App account under her individual name. Defendant further testified that the Venmo account is also under her individual name. When asked at the February 24 meeting of creditors if all her assets were disclosed in the amended schedules, defendant testified that all her assets were disclosed and she did not anticipate the need to further amend schedules. Plaintiff alleges that the defendant failed to disclose the Venmo and Cash App accounts under her individual name under Schedule AB or amended Schedule AB. Plaintiff alleges that defendant repeatedly made false oaths. They're nailing her for everything. They're saying false, everything's false. Plaintiff alleges that the defendant transferred funds from Venmo and Cash App accounts into the bank account of the foundation. On the question 4.13 of Schedules E/F filed on September 14th, 2022, defendant disclosed a student loan liability in the amount of $18,000. The last 4 digits of the account number and the name and the address, and then the creditors were listed as unknown. When asked during her testimony in Rule 2004 examination if she disclosed all her debts, defendant testified no. She further testified that she had amendments to include debt with LASIK Plus, financing for eye surgery, and TriPoint Alliance, a student loan. Defendant further testified that she made a post-petition agreement with the student loan lender to reduce the outstanding debt and that she's making payments of $170 per month. So, she's been lying. Defendant filed an amended schedule on the 21st of December 2022. The amended does not include the debts of LASIK Plus nor TriPoint Alliance. In addition to not listing TriPoint Alliance, her alleged student loan lender, defendant deleted the unknown student loan creditor that was originally listed, so that $18,000, she got rid of it, and we're going to see that in the next one. When asked at the February 24 meeting of creditors if all her liabilities were disclosed in the amended schedules, defendant testified that all her debts were disclosed and she didn't need to further testify or further amend. Plaintiff alleged that defendant made false oaths and failed to disclose all debts. So Ellen's saying she's given them everything they need. They're saying, no, you did not. Count 1 for denial of discharge of defendant. Plaintiff incorporates by reference the allegations contained in paragraphs 1 through 76. Section blah blah of Bankruptcy Code provides the court shall deny a debtor a discharge if the debtor knowingly and fraudulently made a false oath or account. Plaintiff is informed and believes and thereon alleges that defendant made false oath or accounts on the schedules and statement of financial affairs, the amended schedules, the amended statement of financial affairs, and the fee waiver application. Plaintiff alleges that defendant has repeatedly testified falsely under oath during this case at both the meetings of creditors and examination under Federal Rule of Bankruptcy Procedure 2004. Plaintiff alleges that these false oaths or accounts were made knowingly and fraudulently. For each of the false oaths or accounts, defendant should be denied her discharge. Count 2. For denial of discharge of defendant. Plaintiff incorporates by reference the allegations contained in paragraphs 1 through 82. Section Big Code Number of Bankruptcy Code provides the court shall deny a debtor discharge when, with intent to hinder, delay, or defraud a creditor or an officer of the estate charged with the custody of property under this title with the debtor has transferred, removed, destroyed, mutilated, or concealed, or has permitted to be transferred, removed, destroyed, mutilated, or concealed property of the debtor within 1 year before the date of the filing of the petition. So that basically means getting rid of anything regarding proof that you shouldn't get a discharge. Hiding evidence. By transferring funds from her Venmo and Cash App accounts into the bank account of the foundation within 1 year before the dates of filing the petition, defendant transferred, removed, and concealed property of the debtor with intent to hinder, delay, or defraud creditors. Therefore, the defendant should be denied discharge. Count 3. For denial of discharge of defendant. We're almost done with this filing. Plaintiff incorporates by reference the allegations contained in paragraphs 1 through 86. The section code, bankruptcy provides, court shall deny a debtor a discharge when with intent to hinder, delay, or defraud a creditor or an officer of the state, etc., and so forth, property under title, more of the concealing stuff. So they're saying that the plaintiff is informed and believes. He alleges that by failing to disclose her interest in the foundation, control of the foundation, the financial app accounts, that she willingly, knowingly concealed and is defrauding this bankruptcy court. Count 4, it continues. For denial of discharge, plaintiff incorporates by reference the allegations contained in paragraphs 1 through 90. A court shall deny her copy-paste for the intent to falsify things. The defendant has failed to keep information and records of her financial condition, including compensation she receives from the foundation and business transactions as she executes through the foundation, along with any of her other business endeavors detailed in this complaint. So they're saying that because she's not keeping her books, she's not keeping records of what little she claims the foundation does at this point, whatever compensation she's receiving, whatever physical donations she's receiving, she's not filing it. So that's why her numbers are approximate and her answers are vague. She's not keeping track. And so they're saying that, it's her responsibility as a charity foundation owner, as president, it's her responsibility to make sure that these records are kept. By failing to keep all of these records, she is preventing the government from performing a thorough check into her financial condition to make sure that she qualifies for debt forgiveness or debt relief. And then prayer. This is their final thoughts. This is what they want. They want her to be denied discharge, debt relief for all of it. They believe it is just and proper, and I agree with them. And then they submitted it and everything, and that was the court response to Ellen's bankruptcy filing. Now she amended it. She made an amendment. Excuse me. There it is. So, this was 49 pages. 49 fucking pages. But in addition to that, we have other things. I took some screenshots of the things that concerned me. But I wanna... We've got that open, we've got that open. Let's go ahead and open that. And then you've got the OnlyFans open, right? Yeah. So, we'll go through these lawsuit ones. And bankruptcy. To copy. That should go with that then. Okay, so I'm just getting oriented. I'm gonna have to take a short break. I need to take a potty. Oh my gosh, I've been doing this for 2 hours. Alright, everyone get up, stretch your legs. Do something for a moment. I'm gonna go take care of myself for a minute and I'll be right back. Like, I'm not going anywhere. I promise you I'm not leaving. I'll be right back. Alright. Getting these dang earbuds back in my head. Oh, my right ear does not like it. It's definitely not compatible with my whole head setup. Now, I think I already opened the next one that I want to read. I did open it. So, we've already been going for 2 hours, just straight up reading this document. And I want to talk to you all about the other interesting things. The things that happen between the things, you know? We've got, for example, a lot of debts from Ellen popping up starting in 2014, right? She's in Panama starting around 2006. She hangs out there until about, I don't know, 2012, 2013, when I think she starts dipping her feet back into America. And then she officially starts having debts occur in 2014. She's already got the banks mad at her. 2014, 2015, 2016, she continues right on into current. Into 2022, she's racking up debts that she can't pay. And then she files bankruptcy in September. And I find it interesting because she's getting eye surgery right before she's filing a bankruptcy. Now, one would obviously know that if they're going to have a big financial crisis, if they have nothing and have had nothing for a while and are crumbling and their health is deteriorating, as she has claimed, we actually haven't looked at the proof she provided. The stuff that she says are like her exhibits, you know? We should probably look at the exhibits before we look at everything else, because I do want to read you the amended petition, but I want you to see the exhibits. I want you to see the stuff that she sent the court. This is the stuff that Ellen is saying is going to prove that she deserves to have her debts forgiven. That the person she was at the time that she acquired these debts has nothing to do with the person she is now, and therefore, because life is hard, she doesn't have to pay them. Right? That's what we're going to be getting at. I'm just giving you the cliff notes in case you want to go ahead and click out. Because everything from here on out is going to be Ellen calling everybody incompetent and calling herself a victim of the system in so many words. And that they're bullying her. And she don't have time for this. Like, I'm serious. She's literally telling the court, I don't have time to read this. This is one of the most important financial decisions a person can make if they're going to file for a bankruptcy. And she's saying she ain't got time for this shit. But she has time to get eye surgery. And then put that on her bankruptcy debt list. It just, I got issues with, anyway. So, you know what? Yeah, let's go ahead and look at these exhibits, because the exhibits are fascinating. We also want to look at, I'm going to look at this, because this is just one page. We have the rest of it. But it's going to be in black and white. And look right here. There's something I want to talk about with the car here. Christian Janky. I apologize for not knowing how to pronounce this name. I've never come across it before, so I haven't heard it to know what it sounds like. But this person who donated the car to the foundation is also the secretary of the foundation. He's on the board of the Carina Carinosa Foundation. I don't know if that's in any way a conflict of things, but it's certainly interesting. So we have, we're going to read the original document that she submitted. Well, we're going to read the copy of the document that she submitted. And then I want to go back to her OnlyFans. I want to talk about February 27, 2023. I think this is an important date to remember, because it wasn't until July 18th, 2023 that she filed a lawsuit for her personal injury case regarding the car accident. This car accident on November 4th. We are about to see this car accident referenced quite a bit. I want you to go look at that bumper. I believe. All right. Now I just want to Google something real quick because I don't know. Yaris 2010. Okay, so that's basically the car. That's basically it. So $4,000 for a good one from 2010. So I'm thinking they kind of undervalued that car on purpose. Because if it's worth $4,000 now, Blue Book, I wonder what it would have been worth at the time that she was not claiming it in September 2022. So November of 2022, she gets into this car accident, and I want us to all reflect on Ellen's own words. Got rear-ended Friday, feel like I have a slight concussion. Settling this seems to require a lawyer who wants almost half, and I'm busy trying to take care of this precious baby. Yesterday my stomach got worse than I can remember in over 10 years. I'm trying to quit smoking. The next couple of days, alright, she's gonna talking about her fucking woo-woo stuff. And then she ends it. She ends it saying, I'm praying the settlement will be enough to get me into an appropriate sized mom mobile. I need a hatchback high enough off the ground that I can run over a median. So there was also another post where she had mentioned, thank goodness that it was a corporate vehicle. I'll have to dig that up at some point, or it doesn't even matter, I have it saved somewhere. But the important thing is that as soon as November 10th, 2022, she's talking about getting a settlement for her car that was, according to her, donated by their foundation secretary to the foundation, which the foundation head then took control of the car. So here we are, here it is, with her OnlyFans. This is February 27th of 2023. Once again, she hasn't mentioned this in any of her bankruptcy court stuff. All right? The settlement stuff. She's saying, and I highlighted it, still praying for a massive settlement. I was told a conservative estimate is $225,000. I'm praying for that to build an ideal healing retreat. So she's saying, physical therapy is important and I'm regretting strength I'd lost from the car crash. Again, so thankful it was a corporate vehicle. Still praying for a massive settlement. I was told conservative estimate is $225,000. So in February of this year, Ellen was anticipating that she could get a settlement for $225,000. However, I hadn't seen her post a lawsuit up, and then I found this today. Let's look at this. Ellen Ring versus Ramon Mendoza Hernandez in Texas Medical Transportation case filed, civil injury case filed this year. Do you see that date? Do y'all see that date? She did not file for her personal injury car accident until almost an entire year after the car accident. July 18th, 2023. And when an accident, she said, happened November 4th, 2022. And she's hoping it's going to get her into a better vehicle when she settles the lawsuit. Like, under whose behalf is she suing? Is she suing for the Carina Carinosa Foundation? Is the foundation suing? Or is the driver of the vehicle suing? I understand that if it's a vehicle owned by a charity foundation, that Ellen shouldn't be getting anything of personal money from it. So all of this is weird. The timeline, I find, is very strange. The amount of time that she's waited to sue. And then she says she was able to get access to some money from a personal injury case. So unless she has more than one personal injury case going on, did she lie on OnlyFans? Or was there another settlement proposed? Like, what's happening? What is happening? Where did that come from? Who is responsible for helping her get that? It's not disclosed in any of her bankruptcy court information. So that's why I opened it. So here we go. We've got the car in question a year ago, nearly, before she has a lawsuit. And she's expecting money. She's already expecting money. So, alright, we're closing those out because we don't need those right now. Let's look at these exhibits. Now, I did not keep every exhibit that she presented, not because they weren't important, but because I had already collected some of the original from Dave, and right now I don't know where the hell they are. But the important thing is, some of the stuff that I didn't take pictures of or download regarding her bankruptcy case, like that one with the social security number redacted out, that's one of the exhibits, and that's why we don't have everything. I mean, I do have that one though, because there was a second page and I wanted the second page. But some of it didn't seem like it mattered. It really didn't seem like it mattered. I'll go back and look at it at another time and see if the small ones were worth going back and saving, but let's go in order. Let's open exhibit 2. And so this is, there we go, where it explains who the secretary is, and this was signed by the president and the secretary. Just a peek spoiler. Signed by the president and the secretary. So I want you to keep that in mind while we're reading this, alright? To whom it concerns, amended statement of the employment and benefits schedule. This was submitted December 12th, 2022. And this is the language. This is how it is written. I don't know who wrote it, but we know who signed it. Miss Ellen Ring, with Social Security number redacted, President and Managing Member of the Carina Carinosa Foundation, a 501c3 nonprofit public charity with the EIN number listed, in a board meeting discussion held December 4th, 2022, in person with Secretary Christian Jean-K in Austin, Texas, from 1 p.m. to 4 p.m. via Zoom. In person and via Zoom are two different things. I just want to point that out. in Austin, Texas from 1 p.m. to 4 p.m. via Zoom with Vice President Jose Ramirez, it is resolved that due to requirements as a single mother to child Wolfgang Amadeus Ring, we have decided to amend the accounting and volunteer benefits management process effective January 1st, 2023. Ms. Ring will open a personal checking account to be determined for the fiscal year 2023 and beyond. The funds received, the funds received for memberships gained from her following of admirers and spiritualevolutionschool.org will be considered her personal fluctuating direct payment to be sent to the personal checking account for individual tax reporting as required by law. The board recognizes our failure to formally divest these funds since Wolfgang's birth, like it matters. Oh my god, like it matters. They should have formally divested the funds correctly with or without the birth of a child. But anyway, moving on. The reason, and she had him in April. So she has the kid in April, LASIK in June or July, files for bankruptcy in September, has a car accident in November. It is a busy year, 2022. So the reason is that Miss Ring has experienced a myriad of health complications, such as 6 months of bed rest while pregnant, as she received IV fluids for dehydration, anemia causing depression, and debilitating constipation with fainting spells, a cesarean section with a 3-month recovery, the time required to care for the infant, and this most recent automobile collision on November 4th, 2022. Miss Ring's health has suffered tremendously from being diagnosed with scoliosis with a degenerative disc at C5 and C6 pain in her hands from pinched nerves after the IVs. Wait. She's saying the IVs gave her pinched nerves? I want to see doctor's diagnosis. The subsequent physical therapy with out-of-town chiropractic visits thanks to the collision, experiencing aphasia, blurred vision, a fractured spine at L4, abdominal pains, which lead the passing of gallstones that may require surgery and further examinations. If you have gallstones, that's not from a car accident. I remember Grandpa had those. He had to have gallbladder surgery. Having witnessed her agony firsthand, it is with our deepest sympathies that we humbly request mercy from the courts of justice as it may pertain to the following cases: disability, bankruptcy, child support, Medicaid, TANF, and SNAP food benefits. Given the mental and emotional stress inflicted by the non-cooperative presumed fathers of her child, we plead for the state to continue care and treatment for her physical and mental health. We believe it is in the best interest of the child that Miss Ring remain on her prescribed medications. We beseech the concerned parties to provide enough cash support so that she can afford appropriate daycare for baby Wolfgang, who is obviously an advanced child. She's already wanting daycare for a kid that's not even 6 months old. What the hell? This would allow her more time to further God's purpose for her ministry to launch that we hope is a successful nutritional supplements product line in an attempt to remain solvent and further the mission statement of the foundation to help people in suffering and achieve sustainable enlightenment. Ms. Ring volunteers to attempt to work 1 week per month to see clients and individuals of the community in need with expenses reimbursed by the NGO. We aim to keep the organization's balance sheet positive and compliant with federal regulations. Currently, she will remain the sole signatory on the Bank of America business checking account, ending in whatever number that matters, for the Amazon business account. It is resolved that Miss Ring will open a personal account for purchases pertaining to her child and continue to order products for the foundation as needed. A review of the PayPal, Cash App, and Venmo accounts will be completed by December 31st, 2022 to ensure they are fully controlled by the foundation, which Ellen controls the foundation, so to address the problem of account overdrafts due to monthly subscriptions, because the foundation is not eligible for a business credit card, the board agrees to use and refund the personal credit cards of Paula Davis, which are to be listed as business account maintenance fees within the Bank of America account. So the Carina Carinosa Foundation is claiming to use the board agrees to use and refund the personal credit cards of Paula. They are using Paula to maintenance their finances. Wow. Like, I wonder if they really sat down and read this. The police. The board agrees that we will not conduct the Karma Yoga Relief Project this winter as part of our homeless outreach initiative due to lack of funds. In good faith, Miss Ring will continue her homeless ministry by providing baked goods to her congregations at Drum Circle Church, acting as lead singer whenever possible. She agrees to continue donations of household items for families in her community. For the year 2022, it is estimated that she upcycled over $2,200 worth of baby products and clothing, which was donated to her, in more than 480 hours of work on behalf of the foundation. Oh, the year that she was on bed rest. Got it. We will reconvene in January after she has had reasonable time to separate her funds from the foundation to further discuss plans and progress for the supplement's product launch. Until then, her current benefits and compensation agreement will remain in effect. Hopefully by then, the distributor's license will have been approved by the state of Texas and she will have had time to interview a qualified CPA. So Ellen is not even shy about the drugs. Like, they're calling it a supplements thing, but I don't know why you need Molly and ketamine for your supplements. Why are you charging that much for lion's mane, honey? What else are you you don't microdose lion's mane, but microdose shrooms. I am not entirely sure what the logic in all of this is. I mean, this is pretty openly shady. And that was her exhibit number 2. Let's go to exhibit number 3. Resolution of the Board Presidential Duty Statement and Benefits, Ellen Ring. This was written on September 13th, 2021. It says, "It is resolved that the Carina Carinosa Foundation does hereby compensate Ellen Marie Ring, with Social Security number redacted, with her birthday, does serve as minister and program director for the foundation into the foreseeable future. Miss Ring is tasked with the following duties: maintain proper books on the foundation," which she apparently failed to do, manage business expenses, which, okay, file annual taxes with the IRS on behalf of the foundation. Did she even do that? Handle payroll. She definitely paid herself. Manage donations received and given. I think that falls under paying herself. Direct investments on behalf of the foundation. I wonder which investments they received. Direct social media presence. She certainly does that. Perform healings. That's alleged. Create food-based formulas to be brought to market. Okay. That goes into the supplement shop that she advertises but is later claiming is non-operable. Organize or participate in sacred ceremonies either conducted by the foundation or other groups. Ellen cannot conduct some of those sacred ceremonies, the ones that involve drugs, because she couldn't get her Native American church off the ground, as we're going to see later, according to her own words. Organize or participate in, we read that. Author books and materials on behalf of the foundation, including all websites, CDs, apps, booklets, databases, audio, or video content. So they're saying she's responsible for doing all this stuff. I think it's important that we remember authoring books and other materials as her responsibilities and duties. Oversee publication and marketing of all foundation products, meaning they provide products, not just services. Conduct workshops, lectures, retreats, and interviews, book signings, and all other duties of a public figure on behalf of the foundation. Ellen is the public figure here, which is why we're talking about this, not just the shadiness. Direct logistics for the coordination of events, oversee virtual office back-end development such as contact management and call center automation, perform marriages and provide relationship counseling. Performing the marriages she can do. The relationship counseling she can't do without being affiliated with the nonprofit. So as long as she's doing it under the umbrella of the nonprofit as the church and not just selling therapy on the side and then calling yourself a minister on top of it. Provide all manner of services in alignment with the mission statement. Continued from page 1. Due to the economic impact of COVID-19, pandemic, and snowpocalypse 2021, which means nothing in the Rio Grande Valley, Miss Ring will receive the following benefits for her services. It says foundation-related travel expenses covered or reimbursed in full, continuing education expenses covered or reimbursement, housing and utility expenses will be covered in full by the foundation, all operational expenses covered, all alternative health care expenses not covered by her existing insurance will be reimbursed or covered by the foundation, such as dental, massage, chiropractic, acupuncture, Ayurvedic, shamanic, or psychic healing services. So the foundation, which is Ellen and Secretary Kristen Jonke, I know I say different every time, they are bestowing all of this upon Ellen. She's receiving all of these things in compensation for performing all of these services, and that is her exhibit. This is what Ellen is producing to defend herself. To say that she needs bankruptcy. She qualifies for filing for bankruptcy because her foundation gives her everything. I don't know. Like, that's... Next exhibit. 13 damn pages. This is one of the ones that I'm really interested in. Longhorn Neurodiagnostics. This is in Austin. Ellen is filing for bankruptcy in Harlingen, and she's seeing a doctor in Austin. And this is a quote. Okay? And she didn't... as you can see, the accident, November 11, 2022. Or November 4th, 2022. And then it says the date of the visit, when she officially went to see this doctor. It was February. So if you remember, she didn't post until February 27th of this year that she was going to expect a big estimate. And that was just a week after going to see this doctor, right? Before that, she wasn't complaining about it. She was just posting about her daily life and her church and foundation and other stuff. Just her OnlyFans was full of her being active. So we've got this all of a sudden Ellen's expecting money thing coming out of what she's saying. This is from a doctor's visit. It's saying that concussion history, the patient received their initial concussive injury on 11/4/22. The patient had no loss of consciousness. The patient has not suffered concussions, mild head injuries prior to the event. The mechanism of injury causing the traumatic brain injury event was a motor vehicle accident, and the force of the patient's injury was from the back, posterior, anterior. The patient has persistent and lingering symptoms of back pain, neck pain, recurrent headaches, blurry vision, balance issues, interrupted sleep, memory loss, increased anxiety, dizziness, and lightheadedness. The intensity of the symptoms following the concussion has been moderately severe, making normal activities difficult. Now, I have no idea how long a concussion can mess with you, if you even had a concussion. Audio vestibular tests. Platform posturography report. Modified clinical test of sensory interaction and balance. The MSTIB test evaluates the patient's ability, there's typos in this, by the way, the patient's ability to use different sensory strategies, somatosensory, visual, dominance, and vestibular, for maintaining upright balance or equilibrium. This test identifies the patient's ability to maintain stability in various sensory deprived states and compares it to age-matched normative data standards from ages 12 to 89 years of age. The test utilizes 4 specific conditions that will discern with very high probability the location and severity of neurological weakness or damage and identify the potential focus of therapeutic approach. Now, I have no idea what these tests are, but it says that she's failed all of them. Two of them say severe abnormality. And this is someone who's driving a child around in a car. Please make it make sense. Next test, fail, severe abnormality. And I have no idea what all of these tests are. Patient fall risk, significant. Patient's current diagnostic reveals a high risk of fall in the near future that could result in further injury. So she's supposed... Y'all, this don't make no damn sense to me. Okay. I'm going to have to sit down and actually see what all of this testing means. I want to know what all of it stands for. But it is saying no evidence of any nystagmus in any position. Yeah, I really need to look these words up. One of the things that I didn't save was a cost summary. Monkey ladder requires storing numbers in their locations. This test is a good indicator of viewing a situation. See, there's one question in here that discussed banking and finances, and I'm like, why is that in this? Why is this in a brain like a concussion test or whatever. Token search measures working memory. An example of this memory is trying to systematically search for your car keys. Follow the set of dance moves. An example of this memory. Oh, odd one out measures deductive reasoning. An example of this memory is determining whether you qualify for a tax rebate by reading the tax code. What is that even got to do with testing for brain injury? I'm confused. I don't know anything about this. The percentile rank for this test was, like, is that her test result or national percent average? It's got to be her test result. We've got 13 pages of, I don't want to read this shit, signed by, I don't know if they really saw her or if Ellen somehow found a way to cook this up. Cognitive function battery specifically indicates cognitive processing abnormalities exhibited on testing battery suggest a frontal lobe dysfunction causing great difficulty in cognitive performance and concentration and can be indicative of diminished visual scanning and diminished delay reaction time when involved in the cerebellum. Reaction time response inhibition abnormality suggests a probable cerebellar. Are you trying to say cerebular? Dysfunction, diminished visual scanning, and diminished reaction time. Malingering determination made during the computerized testing of the patient's effort revealed a relative result of pass. Patient put their best effort. Does that... I don't even know if that's how doctors type things up. Like, I have questions about the languaging. Some of it gets lax, but I understand that not every medical professional is a machine. You can't type everything perfectly. Typos happen. Neurocognitive testing is consistent with patients who suffer mild traumatic brain injury causing dysfunction of the processing ability in the frontal lobe and cerebellum. B&G testing abnormalities consistent with patients who suffered an injury in the anterior posterior plane. But which one? Anterior or posterior? Which one? Cat hair. This patient's subjective complaints and objective findings are entirely consistent with a head injury and require substantial ongoing vestibular therapy program, oculomotor integration therapy, neurocognitive therapy, cervical and lumbar manual therapy. Based on post-injury subjective reassessment provided by the patient and the review of the objective diagnostic findings, once completely correlated by their respective therapists, the following proposed rehabilitation program for the patient should commence as soon as possible. And here's a financial quote for what these things would cost. Manual therapy of the spine, cognitive rehabilitation, vestibular rehab, This patient's traumatic brain injury increases the long-term risk of developing Parkinson's disease, Alzheimer's, dementia, and other neuromotor abnormalities. This patient should be advised to restrict their sports activities and minimize the risk for suffering an additional concussion or head injury. This just goes on to talking about care plans. And then these are linked sources according to where everything came from. And then this is franchise tax 2018. This says had nothing to do with her medical records, but it was filed with it. And then Longhorn Door Diagnostics, again, concussion history. This is more of that top page again. All tests performed on the 21st of February this year. Abnormal gain in accuracy on smooth pursuit of eye tracking. Abnormal gain in accuracy in high amplitude horizontal microsaccades. Abnormal accuracy of vertical plane fixation. Abnormal accuracy of horizontal and vertical plane fixation during positional head movements. Sensory integration stability. Somatosensory stability, visual stability, and vestibular stability. Dysfunction of greater than 3 standard deviations above norm. Vertigo, dizziness, imbalance. So yeah, it's a summary. There's something in here that I was like, no, significant delay in therapeutic intervention can have a negative effect on the overall efficacy of therapy outcome. It's recommended therapy begin as soon as possible based on the recent diagnostic findings. Additionally, patients may also need psychological counseling. However, this cost is not included. There was also some wording that I thought was just odd. It suggests that she should have additional testing done to her brain. There it is. The patient's condition almost certainly warrants significant therapy to overcome the diagnostic deficits identified on the testing. I would recommend the following therapies to overcome the identifiable weaknesses. So I find this whole little section right here weird. The patient's condition almost certainly warrants significant therapy. Like, why would a neurologist say that? Why wouldn't they just straight up say, yeah, your brain's damaged, you need help? There's a whole lot of dressing up. It felt like. That was Exhibit 5. Exhibit 6. This one was even more sketchy to me because there is absolutely no information regarding the location of this Texas pain clinic, and there are multiple locations. I've Googled the Texas pain clinic. They have more than one spot. So, the date of this was a month before the one in February. 42-year-old female taking, it says she's on ibuprofen, cyclobenzaprine, dicyclomine for abdominal pain, diclofenac sodium, a transdermal. Oh, so that's a patch medication. And she denies past surgical history, even though I'm pretty sure she's had some things done. Says medical history verified. I don't know why that says there. Family history non-contributory. Why doesn't she discuss her family history? Social history, tobacco use, denies toxic habits, denies toxic habits, denies toxic habits. Yeah, she was still trying to quit smoking, and trust me, she's done a lot of drugs. Allergies. NKDA. Hospitalization major. Emergency room for motor vehicle accident evaluation. Denies chills, fever, headache, night sweats. General consultation. Denies headache, night sweats, chills, fever. Denies double vision, blurry vision, change in vision, diminished visual acuity. So this is a month before the big long one we just read. A whole month before she's denying having those issues. But then she goes on in here. Pain management. 42-year-old female presenting to the clinic reevaluation of pain control. And this is going to the bankruptcy court. This is probably also the same stuff she's submitted to the, for the personal injury lawsuit. Patient states she's doing slightly better, but is always in pain. Patient is experiencing neck pain, which she rates a 4 out of 10. Patient states that the pain radiates to the left shoulder to the right trapezius muscle. Patient states that she attributes her left shoulder pain as being exacerbated as she has to carry her 22-pound baby, and this worsens her pain. Patient states that therapy has helped her significantly. Patient does continue to experience lower back pain, which she rates an 8 out of 10 on a pain scale. Patient says that her pain radiates to the bilateral lower extremities. Patient has been taking a medication and Tylenol. She's avoiding ibuprofen due to the possible risks involved with taking this medication. Patient does continue to express abdominal pain, but it has been improving. In December, patient had an episode of biliary colic. I think it's hilarious that she's avoiding ibuprofen back when she used to force me to take ibuprofen. And now she's avoiding ibuprofen? That's hilarious. I remember the rule. Every time I take a drug, you take a drug. I take a pill, you take a pill. Ellen has a hangover. Guess what? I have to get up and take ibuprofen with her. For my bones. She said it was for my bone health. Absolutely ridiculous. Her vital signs. Right. General appearance says pleasant, well-nourished, and no acute distress. Cooperative. I'm surprised. Head, atraumatic, no visible scars or lesion. Eyes, extraocular, movement intact, pupils equal round, reactive to light and accommodation. Ears, tympanic membrane intact, clear, no lesions in the nose, no deformity. Oral cavity, fine. Throat is fine. Neck, thyroid. Examination of posterior cervical spine with point tenderness at the mid-cervical spine. C5, 6, 7 into the left paraspinal muscles. There's tenderness to the right trapezius muscle. Heart, S1, 2, normal, regular rate rhythm, no murmurs, lungs clear. So she basically got a decent bill of health. Yeah, she's got some complaints, but she's otherwise fine after the car accident, according to the doctor. Exhibit 10. Once again, Ellen trying to tell the foundation that her artistic license, when she, in her original filing, said she didn't own any artistic or intellectual property. They're trying to say that this is personal. And Ellen is trying to say, plaintiff cannot prove personal, no direct way to pay, not a separate entity. If it were personal, I would have my birth name on it. So, Ellen is trying to say that her personal secret spa, her Austin Secret Spa, which is the website we shut down, that it's not personal, even though she does very personally advertise things both with and without the foundation abilities. And then she makes no sense. I don't understand why she circled owner when she is the owner. And this person is saying, I'm excited to have found sacred ancestral medicines. And anybody who understands the lingo knows that sacred ancestral medicines means ayahuasca and peyote and the other things that I don't know what they are, but you are not supposed to have in the United States unless you are a tribal person. You can't just be an ordained minister. You have to be Native American, tribal affiliate, so associated, approved, whatever. Like, you cannot be a white girl from Arkansas and start dealing ancestral tribal medicines. So herbs, mushrooms, and other great ingredients. Met the owner last time I was in the Austin area. She's super knowledgeable, natural alternative to Western medicine. She made it easy for me to order, meaning sales have been made. And then thanking Carina. And then this is she says, it's a direct quote. I should change to avoid confusion. I don't even know what she's worried about. The person says, honestly, I used to be very nervous about branching out of my shell and just facing my fear, and healing with Carina Carinosa did exactly that. I can't think its organization well enough. So I don't think she understands how to defend herself. She's saying right here that she has 22 years, when Carina Carinosa hasn't even existed for 22 years. She's barely existed for 10. As a healer and an empathic distance Reiki master, all just... And here's her prices. Remember, I showed you all of this before when the website was working. This was connected to the spa. The massages you're not allowed to give people without a massage license in the state of Texas. So, yeah, we're just gonna... She gave this to the court. She's defending herself by saying her extracurricular... We're moving on. Exhibit 11, the final exhibit that I saved. And it's just, what is a parsonage allowance? It's a definition for a parsonage allowance that somebody published in 2021. A parsonage allowance is a sum of money awarded by the same governing board of a house of worship to its minister to offset housing expenses. For tax purposes, this allowance is exempted from recipient's gross income. A parsonage allowance may also be called a rental allowance or housing allowance. It is important to note that a minister doesn't necessarily mean a Christian as defined by the IRS. A minister can be whatever religion. Yeah, so that's all. Just a freaking broad definition from somebody from 2021 about what is a parsonage allowance, to explain away why the foundation, which is Ellen, is using the charity funds to pay for her living expenses and her other private expenses. So we have 2 other things to review, but we're already at 3 hours. And I have decided I'm going to make this a 2-parter. So this is part 1. I'm going to edit the title so that it says part 1. Part 1. And we're going to do part 2 possibly tomorrow or the next day, because we have... I'm just going to show you what we have to look forward to. We have 49 pages of... Damn, I would really like to just read this right now. And then after the 49 pages, we have her response, which is 11 pages. I'm going to try to power through it. I'm going to use the restroom one more time, and we're going to try to read this because I think this is really interesting stuff. Okay, I'm back. I'm so conflicted. Like, I want to keep going because I'm interested, but it's like I know that I've been here for like 3 hours now, and there's no way that I can cram the rest of this into 10 minutes. Yeah, so in the original filing, no mention of her personal injury case or that she was going to be expecting money. Apparently in her amended filing, all of these medical records didn't start until after she was filing for bankruptcy. So I think it's interesting that Ellen didn't try to rely on previous medical records going into her, into her bankruptcy. Like, at some point she claims that she has scoliosis and she has to get all these shots in her back. And I'm just sitting here thinking, was this since the car accident? Was this since the pregnancy? She certainly blames some things on the pregnancy. We get to find out a lot of what Ellen thinks of this stuff in her response to the complaint. But this is her amendment that the complaint was further addressing. And I'm sorry, like, I can't wear both earbuds. I have to have the other one out of the way somehow. It just keeps moving around. It's so weird. So, we've got some deja vu, but we've got some new stuff happening. And I've got my notes from the first one. And here I've got paper to start taking notes for the second one. This was her do-over to file, basically. And this time, it's filed December 21st, 2022. and it lists both of her names this time, and the Carina Carinosa Foundation, and that it's a nonprofit public charity. And then this time she lists an EIN. And she's listing a private address. I know the house. That was her mother's house. Over 100. There we go. The residence question all over again. Same answer. Chapter 7. Request that her fee be waived. Have you filed for... No. Any pending cases? No. Do you rent your residence? Once again, she says no. And I don't know what at any point she is able to, like, rationalize rent and not having living expenses, but claiming that she has living expenses in the lease that she claimed to have right before Paula died. The alleged lease, the fake one that Dave and Sonia have. Oh my god. My head just keeps circling around all of that. Like, she does realize people pay attention, right? And then, are you sole proprietor of any full or part-time business? No, which I think the charity is a full-time business. So I would say the answer is yes. Not filing under 11. No she claims to not have dangerous property. The briefing. This time she says they are not consumer debts. She says they are business debts. Once again, same answer. Filing Chapter 7. Do you estimate that after any exempt properties excluded administrative expense? See, so once again, she says no money will be left over. Same answer about her assets and debt value. Signed on the 20th. So she actually filled out the paperwork on the 20th of December last year. And then it goes on. Your dependents, 2 dependents. Or 1 dependent, number of people, 2 people. So, and this form looks different than the first one. So now she's saying her family average monthly income is $615. She's saying she receives SNAP and that she doesn't receive, or she doesn't expect her income to increase or decrease. And then she says why you are unable to pay the filing fee if you have additional circumstances, blah, blah, blah. And it says, I struggle to pay basic bills caring for a baby, paying back a student loan arrangement. Completely failing to mention all of the credit card debt that she has. But she is also mentioning that she's living rent-free in her mother's 3-bedroom, 3.5 bathroom home with 1.5 kitchens and enough room for 3 cars in the garage. It's even handicap accessible. The house is fancy. But yeah, go on and cry your poverty. Ellen Marie Ring. Do any of these expenses cover anyone who is not included in your family? She says no. She says her average monthly expenses now are much less. She says it's $1,275, when I think before she had said her monthly expenses were around $2,000. So she's saying she doesn't expect changes. In this one now, she's saying she has $14 cash in her bank account, more than or in her hand, more than the $5 that she had. So she gained $10 in cash assets since then. She's denying having any other bank stuff. She's denying having any other assets. She's denying having paid services. A lot of it's the same answers as before. Once again, signed on the 20th. This is about having her filing fee waived. Summary of your assets. She's saying they're about $4,000. Her personal property is about $4,000. So that's more than, actually that's less than what she said she had before. Because she was saying she had like 16 grand in it in personal property asset stuff. Between her collectibles and her guitar and that really expensive book. And her clothes and furniture. So we'll see. We'll see what all that does. And then now she's saying she's got 29. So 4,000 property. 29. 073.72 debt. Her income. Oh, this is hilarious. 1,127,13. I love the angel number again. And then her expenses leave her with just $1. Meaning she probably realized you cannot submit negative numbers to the government. They're going to ask you how you are paying for everything you can't afford that you have. Are you filing for bankruptcies? Yes. What kind of debt do you have? Here, she switches it up and she says debts are primarily consumer debts. Even though before she said they are not consumer debts. It's really confusing. And now she's saying her student loans are only down to 9,000. So now she only has a grand total of 38 grand in debt. Yeah? Do you agree to pay somebody? No, blah, blah, blah. Do you own equitable interest? So you're going into all of that. And there aren't in the Toyota. Do you own, lease, or have legal or equitable interest in any vehicles, whether they're registered or not? She says no. And she lists the car as the Toyota Yaris that was donated. And it has zero value. Because at this point of filing the amendment, she claims the car was totaled and no longer has it or something. Or if she has it, she's not disclosing that. She calls it community property because it's the foundation property, even though she was the one using it. And then we go on to all of the other stuff she doesn't have, and then now we go into the bedding and sofa is now $1,800. Computer, cell phone, laptop together are $4,000. The frickin' collectibles. Now they're worth $4,700. This is. Now she's saying she's got 12 grand in assets. So, clothes 900, guitar, still no mention of her children. items, like her kids' stuff. And at this point, her son is 5 months, and she's not talking about his car seat, crib, cradle, little stroller, none of the things that he listens to, plays with, chews on, entertains himself with in the house. None of the toys. She ain't considering any of it for this. So, cash says she has none. Deposits money says none. None. Bunch of no security, no this, no that. No trust, no IRA, no family support. Here, maintenance. Does living with your mother rent-free count as maintenance? Trust in equitable or future interest in property. See, these are inheritable things Ellen is excluding. Says she has no insurance, no interest in property that is due to you from someone who has died, which that's the thing I was trying to get at. She's trying to take over her mom's house. She's trying to take over her mom's bank account. She's trying to take over every asset her mother had without even telling the bankruptcy court, unless she's having to update them now. But you know what? They're getting updated whether she does it or not. But she says no. When she's living in her mom's house, planning to take it over at this very time that she's filling this out. Claims against third parties, whether or not you have filed a lawsuit or made a demand for payment. And here she says no. And these two things are the most interesting. At the point of her filing this, she had the car accident. And so she knew that she had the ability to sue over the car accident. And she's saying no. Any interest in the property, once again, her mom's property. Contingent unliquidated claims of every nature, including counterclaims of the debtor and rights. See, I don't know if any of that stuff, the financial assets that you did not list, if the foundation, if other debts being owed has anything to do with it. Describe any business-related property you own or have interest in. She should technically claim that she owns that car as business-related property, except I guess maybe Christian still owns it. I don't know. Inventory. Apothecary. $3,000 worth of apothecary ingredients. That big chest Dave and Sonia found. That's her apothecary store that she doesn't have a license for, that she's been advertising online. Fascinating. She's claiming those expenses. Private investors, $1,000. So back to the farm stuff, crop stuff, a whole bunch of answering no. Total personal household items, 12 grand. Total financial assets, 3,500. Total personal property, 1,640 or 16,400. Like, her numbers are different. And then this is a whole bunch of stuff that she didn't get to fill out because we're not to the claims yet. Here we go. Now we go to her amendment. Now she's listing Credence Resource Mana 4622. $402. What cost $402 that you did in oh, was that when your kid was born? Is that a collection? Or is that just the day when it hit collection? Like, I don't know. That seems like her son's birthday. What cost $402 in Dallas that she didn't pay? Discover Bank, that was back in 2015, $1,500. 2022, yeah, July 18th, there she is getting LASIK surgery. $1,400. Right before filing bankruptcy. Bank of America, that whole song and dance all over again. Barclays Bank Delaware, she listed that again. Capital One again. Citicards, CB&A again. Rent Debt Automated Collective, or COLE, I don't know what it stands for. 2021, Synchrony Bank Care Credit 2021, USAA 2019. And that's it. She doesn't list the $18,000 anymore. But now she has $9,180 in student loans, and absolutely none of these were for loans. These were credit card or things that had gone to collection agency. So let's just go with the things that only say collection. 402, medical, credit, 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 collection, 3,454, collection, 493.88, credit card. And so let me paper math this out. So that's going to be 9, 14, 13, 4. So even if we were only using the collection agencies, that's $4,349.88 of student loan debt that she could collect from ambiguous collection agencies, or she could owe to ambiguous collection agencies, and everything else is listed as a credit card. Credit card is not student debt. Student debt is when you get a loan for college and you pay that loan that you got for college. When you get a credit card and you pay a school, the school is paid. You owe the credit card company now. That's how that works. So it can't be student debt if you don't own the financial institution for a student loan. So I don't know where she's getting that. Where is she getting that $9,180? She had mentioned having something renegotiated, but I don't see any evidence of renegotiating. And then here she is once again restating that she lives at her mother's house and that this time she's employed. She's stating that she is employed and that she's a minister and that she's been employed at her mother's address since 2017, when if we look at prior documentation, she was in Austin from 2017 until whenever she was claiming residence at her mom's house in like 2020 or 2021. Estimated monthly income, $611.13. More of those angel numbers. A bunch of zeros, and then right back to calculate monthly take-home pay, and then SNAP benefits, which it looks like those had increased since the time she first filed, and then monthly income. All right, fine. So they're saying between SNAP and whatever that take-home pay is, for I don't know what. I don't know where her numbers are coming from. She's claiming that. Is this a joint case? No. Your dependent's age, she failed to type 5 months. Instead, it just says 5. So that needs to be refixed. Home maintenance, repair, and upkeep expenses. She's claiming to pay $40 for a home that she does not rent from, according to her. Now she is claiming no electricity, heat, gas, no water, sewer, garbage, no telephone, no cable. She's claiming only food and housekeeping supplies, childcare, education costs, medical, dental, and vehicle insurance. Everything else that she was saying that she was paying for. Transportation, she's apparently not paying for Uber. I don't know, her rides are manifesting for free. Maybe she's riding a broomstick around. Clothing, laundry, and cleaning. Apparently none of that. No more personal care and products. None of that. Who's paying for any of this stuff? Apparently not her. She's not claiming it. So, just a whole bunch of zeros. And then we get to calculate her monthly expenses again. It's back to that same number. And her net income is, according to her now, $1.13. And she expects things to change because of childcare costs. And then she continues to go on with not married and previous address from 2015 to 2021. She was in Pflugerville. So I don't know, like, how has she employed at her mom's address since 2017 if she's been in anyway. So within the last 8 years, did you ever live with a spouse or legal equivalent? And she answered to all that. Then none of that matters, though. And then here, this is where we start getting into her finances again. Did you have any income from employment or from operating a business during this year? She says no. She says her wages were nothing. And then we go into, did you receive any other income? And the other income she was receiving, she's now calling it membership, not residual. They're memberships now. And her membership for the current year, it went from being $11,000 to only $5,000. Angel numbers, of course, 5,515 cents. And then her SNAP benefit is the same. And her SNAP benefit is also the same for 2021. However, her income for now, what she's calling membership instead of residual, it was $12,432. Now it is $8,766. So she cut that almost in half. Yeah, she's cutting these numbers in half. And then for memberships, she's claiming that she got $1,094. And then emergency aid. So instead of saying that she had just the emergency aid, she's including the membership. So she failed to include the 2020 membership or residuals in the original filing. So then she goes on to primary debts, whatever, is within a year, did you make payments and this and that? And it's the whole, did you do this, yes or no? And then within 1 year before you filed for bankruptcy, were you party in a lawsuit? She says yes to the child paternity one. It's got the case number and everything on it. It says it's concluded. But it does not include the Citibank one. She left that out. So that's not here again. And then it goes on to, within 90 days, did you or any creditor, including, set off any amounts from your accounts or refuse to make a payment? No. Within 1 year, did you, blah, blah, blah. Just a whole bunch of her saying no, she didn't do anything. What did you donate? Your charity. She said before she never gave anything more than $600 worth. So here now she's saying she gave $3,500 worth of charity in physical goods in the year 2020. She's actually saying December 12th, 2020 is when she's claiming all of this charity. So that was in Austin. And then more answering no to questions. More answering no. More answering no. If anyone on behalf did anything for her financially, buy, sell, trade, property, this, that, I'll just a whole bunch of no. Her saying she ain't got nothing. She ain't got no help. No one helped her. Nothing's happening. And then it says, have you stored property in a storage unit? And here it actually lists the place. I know where this is. I know exactly where this is. And it says as a filing this that she still had it. So she's been storing some of her furniture. She's got furniture that's not been in her mom's house. I'm pretty sure she's working on moving that too. Do you hold control of any property someone else owns? This time she's not including the car because the car is at this point totaled, according to her. Environmental law stuff, answering no to stuff, answering no to stuff. Answering no to stuff that is inaccurate because she definitely was a member of a limited liability company. She was part of and at the head of these businesses that she's going to later come to say are failures and non-existent. And then her signing off that she's read everything and it's all true and nobody paid her. And then they certify that a debt payment plan was not prepared in August. So, before she's even getting her eye surgery, she's dealing with this debt company. She would have already had this and didn't submit it. So that's weird. Like, I don't know why that wasn't part of the original one. And then September 28, 2022, she completed a course. So a week after her eye surgery, or not a week after, a couple months after her eye surgery, she completed a course doing this bankruptcy thing, and then she had a car accident. And that's her amended one. And her response is hilarious. Y'all, her response is hilarious. If you need to get a snack, get a snack. If you need to go walk your dog or stand up or do something, go ahead and do it. But this is going to be the end. I'm going to read this and then that's it. I won't have anything else to talk about. I just wanted to get this out here because I think her bankruptcy stuff is really weird. I think the way that she was answering some of it was very she's trying to double speak by saying she has but doesn't have assets. So she's obviously not intending to file bankruptcy on the charity, which I initially thought she was filing on the charity, and it turns out, I guess, that she is doing the filing for herself while continuing to work for the charity and have the charity support her and have the charity be her way out of paying for her debts. So because of the charity, she's not responsible for anything. Because life is hard, she doesn't need to be held accountable to pay for anything. All right, we're gonna do this. This was filed in the response to the response. All right, she filed her whole thing, and the court, in September 2022, and the court was like, hey, now we got a problem with some of this information. And so they said, hey, we need you to bring us this. We need to have these amendments done. Like, where's the rest of your accounting? And so she got her amendment, and because she doesn't have a lawyer, this is her response to where the rest of it is. When this Epstein, Jimenez, whoever is officially being the voice in the courtroom, this is what Alan is saying to him. after they said, hey, we don't trust you. We think you're hiding stuff. This is what Ellen says. To the Honorable Eduardo V. Rodriguez, Chief United States Bankruptcy Judge. I, pro se, fictitious person Ellen Marie Ring, with redacted social security number, object to all findings presented to the unknown to me, Kevin M. Epstein, United States trustee. I find it rather astounding that a third party is now trying to extract blood from a turnip and make false and misleading claims that were already addressed in the December 21st, 2022 Rule 2004 examination, along with emails and attachments sent to Miss Catherine Curtis and Mr. Andrew Jimenez. I pray the judge reviews the following 12 exhibits attached directly rather than dragging out a game of hearsay through non-direct involvement on Mr. Epstein's part regarding various codes, not laws. Okay, so laws are there to enforce codes, and codes are there to help hold up laws. So anyway, statements of defense by debtor. 1. I, Ellen Marie Ring, am sovereign in the name of the highest truth, love, light, joy, and compassion, aka God, Jehovah, Yahweh, it, et al. I, Ellen Marie Ring, am not the fictitious straw man person, Ellen Marie Ring, created by the federal government, and am beholden only to my creator. The word I refers to the great I am, that I am, aka Christed consciousness embodied. Buckle up, y'all. The debts have all already been discharged. No, they haven't. There are even debt relief programs now available so that people can eliminate debt without having to go through bankruptcy. As a single mother, disabled, and injured in a car wreck through no fault of my own, this is quite a slap in the face. I need to be asleep with my baby at night, not spending dozens of hours cultivating responses on the merry-go-round riddled with conflict of interest. It is my understanding that the trustees have a financial interest if able to retrieve, disprove, or deny discharge, which is unethical and immoral given my fragile condition. She's saying that the trustees have a financial interest in her having to pay her debts to the multiple credit card companies that she's owed since 2014. This is so dismissive. Continuing. 3. If Miss Curtis was able to realize the validity of my claim, and the Texas Health and Human Services was able to recognize and award us state services, and no housing authority will accept the foundation's funds as my own, then why are Mr. Jimenez and company having such a hard time understanding the situation? I do not have free time to read documents. She underlined that. She underlined, I do not have free time to read documents. This is an out-of-work person who's been on bed rest and has nothing to do but sit around and possibly read. She continues to say, I have a 12-month-old baby at this point. He was 12 months, so a year. I had to hold a baby bottle for about 7 hours a day for 6 months while studying how to make formula during the shortage crisis in 2022. My sleep is still interrupted more than 5 times a night with caring for an infant. Here I am burning the midnight oil again, which is not what a compassionate human would require of me. I fail to see why it is so hard for your crew to comprehend that I am not able to repay these credit card debts. I did my best to service the debts in good faith, and I did my best to file the amendments. 4. It took more than 2 months to fill out the questionnaire provided by Upsolve NGO. At no point was I allowed to go back and amend answers using their platform, and was unable to help make proper adjustments or provide timely or effective email replies when I tried to get help or consultation. Their platform does not provide for adjustments as requested by Ms. Curtis. I do not like to procrastinate, but the baby demands quality attention. Yes, I failed to review the dozens of pages before signing in the wee hours of the morning while babysitting, and for that I am at fault. She calls it babysitting, not mothering. And she underlined it. She underlined, yes, I failed to review the dozens of pages before signing in the wee hours of the morning. Probably the only reason it got done is that I was being sued by a creditor because I could not make the payments that had a deadline. It was all I could do to get enough paper and ink to work for the printer. Thankfully, the secretary did agree to cover costs for resupplying office materials needed for this process and future business, for lack of better term. By the way, it's way cheaper to just go to Office Depot or whatever your local office supply store is and pay for them to print out your copies. It's way cheaper to do that than to buy ink and paper. So anyone who needs to save money, who's actually in need of help. 5. There was an ongoing difference of opinion in the semantics and interpretation of the SOFA's wording. That wording may not have been exactly the same via Upsolve's application technology. I only fully viewed the official government site forms on December 19th, 2022 after Upsolve failed to provide customer support. Mind you, I suffered a traumatic brain injury on November 4th, 2022, which impeded my ability to respond. Ultimately, Ms. Curtis understood and deceased the witch hunt. Perhaps her being a mother is the key difference in these men's inability to comprehend and concede. Please see Exhibits 1 and 4. Now, this is Ellen saying that other people are incompetent, bullying her, and she's had a health issue, therefore none of these things are her fault. Nothing. She can't be held accountable for any of it, even if it is her fault, because of all of the things that she said. Anyway, direct responses. This is where she speaks directly to the plaintiff allegations. To number 19, she says, I failed to attend the November 28th meeting for 2 reasons. 1, the trustee's office did not send the proper notice, and 2, I suffered a concussion on November 4th that significantly affected my vision, speech, disrupted my thought patterns, aka aphasia, and short-term memory. We are now 5 months later. My brain and vision are just beginning to function more normally. Attached, you will find supporting documents. Please see Exhibits 5 and 6. Funny how that one doctor said her vision was fine in January, and then it was all of a sudden worse in February. Allegations regarding Carina Carinosa Foundation. 25. I, Ellen Marie Ring, do not sell books, nor is there any proof that people pay specifically for value-added services or products. The belief that I have destroyed documents, etc. is unsubstantiated. It's hilarious that she says she does not sell books when the foundation clearly states that she is there to write and sell their books. Okay, moving on. So, at number 26, at any given time there is a handful of volunteers working directly with the public who may or may not be reimbursed financially with products. Evidence is hard to prove regarding indigent care because of the many barriers to restabilizing their lives. I do plenty of volunteer work. See Exhibit 2 dated 12/12/2022. Is she talking about that one time she donated furniture in Austin? 27. I do not have a personal bank account. I am still deciding with whom I want to bank, and my personal income, as defined by the foundation, is going to cover business-related expenses, as it always has. 100% of my money is donated to further the mission to help people in suffering and achieve sustainable enlightenment. With transfer fees and time delays, it does not make financial sense to keep separate account yet. See Exhibits 2 and 3. And so all of these things that she's providing. Some of them we've looked over. They're supposed to explain in some way why it's okay for her to have all this centralized, like this targeted control, just her being in control of things. Number 28, Section 107 of the Internal Revenue Code, which, by the way, is not a law, she says, allows the minister of a religious body to exempt some or all housing allowance from gross income for tax income purposes. The written and signed resolution of the board as a minister covers cost of rent, utilities, and alternative therapies not provided by the state of Texas. Now, she's saying that she can cover her housing costs, of which she says she pays no housing costs. She pays no rent. She has no lease. Fascinating. So in 29, see Exhibits 7 and 11 to clarify what services I provide. She doesn't even explain them. She just says see the exhibit. Number 30, I was never asked to present the business plan of the foundation. That was handled in 2017 directly with the IRS. Everything I do now is within the scope provided to them. I may be mistaken, but I think the distinction came down to the sale of products should be limited to 30% of the overall revenue generated. Plaintiff cannot prove otherwise. So this is arguing with the amount of money that she's even supposedly getting for sale of products that she's claiming that she doesn't sell. Remember, everybody, she both does and does not sell things. Plaintiff has zero evidence in the bank statements which would indicate that products or services were sold. Just because there are websites listing services or products does not prove sales have occurred. Lacking further evidence unknown to me, plaintiff assumes a belief to the contrary, including destruction of evidence. He cannot prove something that did not happen. The wrong person telling your story will always make you look bad. She is not speaking in any proper legal format. She is also saying that all of the products that are involved with her don't get sold. She doesn't sell the things that are sold. Like, I don't understand. Make it make sense. Number 32. In the first sentence here is underlined. Don't believe everything you see on the internet. And it goes on to say, the Native American Church of Peace was never discussed because it was never finally formed and has since been removed from the main website. It was not formally formed because the presumed president's daughter had a baby, and she too went MIA because infants are a four-handed job with no overtime pay. So Ellen is claiming that her Native American Church of Peace never happened. So the Native American Church of Peace is her way to be able to offer tribal medicines. You can't legally do ayahuasca ceremonies and peyote ceremonies outside of the tribal scope. So Ellen has to have someone do that. And she's saying that it didn't happen. So any drugs that she has on her relating to this tribal stuff are unlawful. She can't have them. Then she goes on to say, Freedom Equity Lenders Real Estate has no EI in her bank account. I do not recall it is even a registered name. Powerful Energetic Medicines is a URL with a list of services with no payment processor. It was found via CarinaCarinosa.com, which was documented and presented to the IRS in 2016. It could be considered a DBA, but the current actual DBA is Healing with Carina. OnlyFans is a space for unhealthy admirers who do not meet my strict requirements to be clients. I literally have had 3 of the previous 900 followers convert into sessions. Images of those earnings were provided to the original 2 trustees. Those earnings are considered personal enough that the foundation uses them as my funds. All of my funds go directly into the foundation's account because maintaining our online presence with the webmaster's salary takes almost every dime. That's important. These are the same funds provided as evidence to the Health and Human Services Department. Mr. Epstein should be ashamed of himself for trying to literally take food out of the mouths of babes. So talking about the webmaster's salary goes hand in hand with the fraudulent payments made through, I believe, the Wells Fargo account to Ellen's websites that are no longer there. So all of the websites that are being listed here, Powerful Energetic Medicines, the Freedom Foundation Equity thing, Money Magic Miracles, Carina Carinosa Foundation, all of those websites were apparently being paid for by Ellen directly, where she says they're not hers. Well, why did they get shut down when Wells Fargo flagged her mom's account for fraudulent activity upon her passing? Why were those websites caught up in that if Ellen wasn't directly maintaining them? Number 33. Plaintiff's allegations are unsupported. I'm not going back to look at what that was. And then she goes on to say, to answer my point of contention, Magic Money Miracles LLC is not mine, even though she was the one on... She said it was powered by the Carina Carinosa Foundation. I have a screenshot of that. I also investigated that website live, and you can see everything that Ellen claims to be as her intellectual property as part of Carina Carinosa Foundation. She says that Mr. Jimenez proved that her name was not on the registration document, and she proved that there's no beneficial owner in the attachments early on. So, look, Magic Money Miracles LLC is hers. It was powered by the Carina Carinosa Foundation, and the website was shut down when Ellen used her mom's money, and Wells Fargo said, no, never mind, you can't be doing that. So yeah, there's things happening. So it goes on to say, it is an idea, a method, provided by a team of lawyers in San Antonio. It has no bank account, nor any EIN, nor has a penny been made off of the business plan, nor does it have any employees, even though it listed 3 employees, one of them being Ellen. It's just a great idea with a website. It was a plan in a drawer in storage with a live website that we maintain in case the space arises in the future to move forward. I truly had forgotten about it. No, she hadn't, because she was paying for it. MMM, which is the Money Magic Miracles or whatever, would become the bread and butter for the foundation so that we could fund Freedom Equity Lenders real estate, which would serve veterans and provide affordable housing for artists and healers. Therefore, it is reasonable to believe that I simply forgot about it while filling out the form. If your forensic investigators are worth their salt, they should be able to confirm the last times the websites even got updated, it's a moot point. So she's trying to say that everything that she had set up and everything that she was advertising doesn't mean anything. She's honestly saying that her word means nothing. That's what I'm getting from this, is that she's allowed to publish things that don't mean anything. And she's allowed to do them just in case. And have them live and let people think these things exist and put phone numbers and email addresses and people's names and faces on them and talk like they're real, and then go into court and say, oh, actually, it's not real. That is messed up. So then she goes on to say, Mr. Jimenez failed to prove his attempt at pegging me as a beneficial owner. Mr. Curtis did as well. I have proven I am not the beneficial owner of the 501c3 nonprofit public charity the IRS was able to understand. And see, I need proof, because Ellen is the president and her name is on the whole damn thing. So I need to start digging into more of those smaller files that got submitted. And then she says, allow me to repeat what I already said in the December deposition with Mr. Jimenez. Did I read all of the document, and is that my signature? No, I did not read through the 80 pages before signing. I used a nonprofit website over the course of 2 months and a checklist to sign on the dotted lines, it is reasonable to conceive that my life is a hot mess right now, and it is going to take a few miracles to get me out. I proved to Miss Curtis that I did not feel like I was lying. I do not hold 5% shares or more of anything, and I do not have any personal property that I could repay the debts. I did my best to service the debts on these loan traps that Bernie Sanders advocates the government amend be at lower percentage rates. I got stuck in the debt hole while making a baby, and with HHS lowering everyone's food stamp benefits, I really have no idea how to keep a balanced account given this recession. So Ellen is once again passing the blame. And 34, she says, yes, I failed to accurately disclose my income from the foundation and the schedules until I was able to make amendments in late December. It's a very convoluted gray area to deal with. Miss Curtis understood. Why is it hard for the boys to believe? And there she is. She's pointing fingers at other people. She likes to blame everyone else, I've noticed. I made appropriate amendments, which it seems Mr. Jimenez never bothered to read, but Miss Curtis did. And I don't know why she thinks Miss Curtis is going to come in here and save the day, but she is shining up Miss Curtis like they're best friends or something. Number 36. The appropriate amendments were made in December, but the fact remains I cannot get a rental agreement claiming the foundation's funds as my own, so it's not my money, as the plaintiff believes. A belief is just a thought you keep thinking. You are welcome to change your thoughts in an instant. A belief does not constitute facts beyond a reasonable doubt. I doubt the plaintiff can substantiate his claims, and I'm offended that I have to defend myself against the hearsay of yet another stranger lurking online. Cease and desist, stranger. This is weird that she's even saying all that stuff. What do you mean she cannot get a rental agreement? Is that her mom's refusing to give her one because that was the smartest thing Paula ever did, was refuse? Number 37. She says the $10,500 in 2020 came from a housing grant, even though she listed it as emergency relief. It was like, what the hell? The $12,432 from residuals is the fuzzy part, but that was my OnlyFans money. Those residuals are funds received for memberships. The only reason it has been considered my money is because the foundation had to give something to show for the IRS. Oh my God, that makes no sense. But the funds are received by the foundation, and apart from a storage unit cost, all other is within range for my compensation package, which I was provided, which you provided for yourself. That's the thing. The compensation package that Ellen was provided by herself, to herself. That's the whole point. She says, I gave screenshots to Miss Curtis from the Bank of America app, which show the budget breakdowns for the foundation. I have faithfully stayed within those ranges, and plaintiff cannot prove otherwise. She's daring them to prove. Plaintiff's claim is too vague to comprehend for number 38. Number 39, upon information and belief, defendant's gross monthly income is at least 4 times the amount she listed on Schedule 1. And then she says, show the evidence in the bank statements to support your belief. Plaintiff, there was one $10 purchase at the Tipsy Tavern before receiving a massage. If anybody knows what the Tipsy Tavern is, raise your hand. Yeah. That Tipsy Tavern. So, I take so many pills for pain management that it makes my navel bleed. Right. One of those pills is a muscle relaxer. I was not receiving the medication at that time, thus it falls under the ROB for reimbursement by the foundation. Number 40. Praying for people is not a good for-profit business. I do not receive personal income. I have taken several oaths and vows to further spiritual and natural methodologies to help in suffering. The only person who ever said, here, go buy yourself something nice, was the secretary of the foundation for Christmas 2022, so Christian Janky. People just bring me flowers because that is what I ask for as a tip. All other expenses are covered by the foundation for one valid business reason or another. As I said in the December meeting, originally I was supposed to get $52,000 per year, but we have not been able to break the glass ceiling, which warrants extra reporting or individual accounts. I am sorry that it is nearly impossible to find a volunteer CPA who understands the tax filings for a nonprofit. Once again, she is blaming other people and trying to evade responsibility. Answering 41 and 42 together. I did not provide bank statements for 2020-2021, the bank application does not allow me to go back that far, only 1 year. The numbers I provided were in line with what I was able to pull through January 2022. 43 and 44. Pretty sure the income amendment was provided. Yes, I do not earn enough money to cover my basic expenses. The balance came to $1 and change. Now we actually receive less food stamps and have lower membership sales. It is a constant source of stress. It has been like that since December 2021 when I had to go on bed rest while in a high risk pregnancy. I do not believe the plaintiff has experience caring for a newborn. Excellent defense. Gee, yeah. Anyway, I'm being sarcastic, by the way. Number 45. Upon information and belief, the foundation received an average monthly income of $2,890. This does not make it Ellen Ring's money. That amount also stays within the HHS guidelines for number of people in our household, so plaintiff trying to get our food stamps and health benefits cut makes me need psych medication. How dare he refuse an innocent child appropriate health care? See Exhibits 4, 5, and 6. Number 46, I was not authorized by the board to pay the filing fee because the credit cards are in my personal name. Oh my God. I was not authorized by the board to pay the filing fee because the credit cards were in my personal name. We did not actually hold a board meeting about bankruptcy until December 2022, which is documented in Exhibit 2. I cannot change the fact that nonprofits are not eligible for business credit, nor can I change the fact that all the new businesses are not eligible for credit in their first 2 years because of the average percentage of startup failures. It's more than 75%. Once again, passing the blame. Page 6 of 11, we're almost there. And she goes on to say, I answered all the questions from Ms. Curtis and Mr. Jimenez entirely honestly. As a result, she understands the differences in interpretation for specific wording in the forms. I actually only saw the forms from the official website 36 hours before the December hearing with blurred vision and aphasia from a moderate concussion received on December 4th, 2022. I like how she throws that out, but not the fact that she's suing for it. Perhaps she understood because she too is a mother and could entirely emphasize with cross-eyed sleep deprivation and PTSD that comes along with raising a baby by oneself. I submitted the changes via email just hours before the deposition. I pray the court accepts my apology for the tardy reply Ms. Curtis did. Thus, Mr. Jimenez failed to read through all the attachments I presented as proof, several of which were given to him well in advance. I turned in the amended forms immediately after the hearing with the baby in tow. This should not be hard to comprehend. I emailed Mr. Jimenez and Ms. Curtis every time in the wee hours of the morning, just like now. The question is, can I repay the debts? The answer is not without a miracle. Am I supposed to go up to Austin for work 1 week per month? It is cost prohibitive given the dramatic inflation and devaluation of the US dollar. I do not have a spare penny for investments, much less to cover the cost of traveling, than to turn a profit and to have the baby well cared for. My situation is not unique and should be easy to comprehend. Miss Curtis understood. So Ellen is blaming everything but her. The questions about me selling products and books have all been answered multiple times in the same ways, and you're welcome to go listen to those proofs. The fact is, the bank statements don't reflect any individual product sales because that's not what happens when people come to see me. As previously stated, people buy time. Often they donate at a premium rack rate. I turn around and donate my time to those less fortunate. Mr. Jimenez tried to pull up some lame evidence of 3 donations I made on Cash App to women on Facebook who were asking for help. My commitment to the nonprofit is to tithe 20% That is what I give rather than paying taxes. I am the woman giving $20 bills to homeless people in the streets. I buy food for starving artists, of which Austin has plenty. I am the person who involves the community to participate in Karma Yoga Project, which gives basic supplies to the homeless. My God, where are you getting these $20 bills if nobody is buying anything from you? If no one's paying you, where are you getting the money to hand out? Okay, whatever. Moving on. Plaintiff presents the argument that PayPal, Venmo, Cash App et al. Are personal accounts. What I said is that at the time of account opening, those applications did not have a section for business or nonprofits. After the meetings with Ms. Curvis, it became clear we had to handle that aspect, which is disgusted. That's a typo. In the December resolution of the board attached, see Exhibit 8, the payment page is in our principal website. I talked to the webmaster about changing it from payments to donations. I cannot change it for various technical reasons I am incompetent to explain. The general donation page on the main site clearly includes liability waivers and discussion, business to client style clarifying content. 7 out of 11. Oh my God. If the Bank of America was able to comprehend that the personal cards were for business purposes and give us one back office that linked all the accounts to the nonprofit's account, why is plaintiffs confused that all transactions were business related? Screenshots were provided showing budget breakdowns. In the bank statements, plaintiffs did not find any instances of me shopping for Gucci bags or clothes or any personal items with the exception of some massages and one bar tab. I presented sufficient evidence that alternative medical reimbursement is a benefit provided by the foundation. He literally said that I had provided so much evidence in so many emails he could not keep up. The invitation is for you to review the evidence provided today. I have provided proof that the nonprofit has no beneficial owner. I have provided evidence that I do not even get paid $5 an hour for my work. The webmaster makes more than I do. That is so conflicting when she says how much she gets paid versus now she doesn't make anything. Which is it? Evidence shows that I was seriously injured in a car accident November 4th, 2022, ? She says, my spine was severed. I thought she had a mild concussion and scoliosis. Anyway, my spine was severed and the doctor recommended $120,000 in 2 months. I am receiving a nerve burn this week. I have undergone every kind of ultrasound, MRI, CT scan, and x-ray they have. The question of the vehicle I supposedly had beneficial control over was totaled. The new vehicle is still not in my name due to RGV style incompetence. Now she's blaming the valley. The stream may cut off. Quality is really bad according to my YouTube thing. So, allegations regarding the foundation's bank account. Number 50. The closest proof the plaintiffs have based on the bank account statement was one large purchase through Amazon. I testified that was to buy the 16 ingredients and packaging for the Brain Booster Scoops formula, which we still have not sold online to the public because we are awaiting a supplement distributor's license and consultation from a qualified CPA. Such things were presented to the IRS in 2016 and found to be in alignment, objection, speculation. So she's saying that she's been advertising for a business that she doesn't have a license to operate. She has the things to... She has an app and a store. She has all of this stuff. And she's saying she has everything, and yet she has nothing. Number 54. Plaintiff's claim is misleading. Refer to ROB compensation schedules. Number 57. Objection, speculation, misleading. What property am I alleged to control? I control, not own a bank account. and a lot of content on several websites that comes with certain benefits. You see, the thing is, I testified in the rule examination until the foundation is able to pull in enough financial resources to break the glass ceiling. I'm filing requirements. We are not big enough to warrant distributing a personal salary for my work yet. Number 58, plaintiffs have failed to provide supporting evidence, objection, speculation. Number 61, plaintiff's claim is misleading and unsupported or have connection to any business. If there is no EIN, there is no business. None of the aforementioned business entities have an EIN or bank account. Show your proof to the contrary. Objection, their lack of evidence does not equal destruction or evidence on my part. I have been very forthcoming. I just did not file the amendments in time, which is an argument plaintiff already dropped. Number 62, agreed. I did not disclose the equitable interest in the SOFA. I have an interest, but not beneficial ownership. The wording on the forms does not specifically state any interest at all. It is a matter of legal interpretation best left to the judge, not the people who stand to profit at my loss. Number 63, none of the listed business entities are registered or have EINs, nor do the bank account statements support these allegations. A website, photos, or online profile does not constitute a member, partner, officer, director, or sole proprietorship. All websites intertwine, which is how plaintiff was able to find them in the first place. There is no hiding. We have paid for years to build our search engine optimization. Our stats are astounding. Our conversions are very low and on par with average marketing campaigns. Number 64. All the funds generated are disclosed within the bank statements. Plaintiff cannot prove otherwise. Number 65. Miss Curtis was able to understand and step down. Number 67. They were under my individual name only because coding did not exist at the time of account opening. December resolution of board clarifies that clerical incompetence, errors, and adjustments have been made since. See Exhibit A. There is no hiding. Number 69. Yes, I failed to disclose them because I do not operate any personal businesses with those accounts because it is difficult to extrapolate my personal income. I am not required to pay state income taxes. I use the Cash App filing system to present something to the IRS. It was the only account in my personal jurisdiction. Excuse me. Plaintiff fails to charge me with using a misleading DBA. If it were truly personal, it would have been in my name, Ellen Ring, not the artistic license provided by law. The numbers were consistent with membership subscriptions and in keeping with Department Health and Human Services. 70. What property? Objection, speculation, plaintiff lacks evidence. 71. Yes, I transferred all the foundation funds from all payment processors into the foundation's account for ease of bookkeeping, which she didn't keep, as testified in December examination. Allegations regarding failure to disclose creditors. 72 and 73. Yes, I was guessing what my student loan debt was. To my knowledge, it had been written off years ago for non-payment, as in she was trying to avoid it. I had no way of looking into it for clarification. You mean she was avoiding it? The day after first speaking to Miss Curtis, I got a call from someone who was able to help consolidate the loan and provide exact details. I agreed to pay that instead of a lawyer's fee. No attorney would take an already active case anyway. Oh my god, that is such bullshit. Proof. Need proof. Page 9 of 11. We're almost there. Number 74. And she is so fucking long-winded. 74. I believe I have testified that I had gotten a piece of mail after the initial filing saying that the TriPoint Alliance, which finances LASIK Plus, had come back with an address issue, unable to deliver the mail. It said something about not being able to contact them at that address. When I called LASIK Plus to verify, the agent told me it had been written off already. I was not able to figure out how to resolve that aspect, or at least I do not have FA, which is why it's coming up for discussion. As for the student loan, I still do not know where exactly that stands. I do not have time to dive into it. And 2, there is a debate on Capitol Hill as to whether those consolidations would go through. The process seemed to take several months to resolve. I do know that my new personal credit card is being drafted the $170 per month. And again, you know about it, so I must have disclosed it somewhere. Plaintiff cannot prove intent to hide. Now, she's got that $18,000 in student loan and then the $33,000 that her mom was paying, and then dad was like, wait, no, she forged my signature on that. No, that's a crime. So he reported it, and the loan company was like, oh, okay. And so then they started to investigate it. So we'll just have to see if anything comes out of that 33 grand. 76. Defendant testifies, I did the best I could with what I had to work with at the time. 78. I did not knowingly or fraudulently make a false oath or account. There seems to be a fundamental disagreement in beliefs between both parties. I believed I was providing accurate information to the best of my ability. Given the many medication conditions, it is reasonable to doubt plaintiff's accusations. My God, Ellen. Just take accountability. You intentionally left stuff out. Number 79 and 80. I do not believe I have provided false testimony. I do believe that in good faith I need a qualified CPA, and that until and if that happens, I should hold off on ramping up further business models. I have been trying to find one qualified to consult on the sales pitch for Magic Money Miracles to ensure its legality. In tandem with the foundation as shareholder, nothing was ever formalized. Plaintiff cannot prove his belief is anything more than just a thought, much like the MMM sales page, which has no user traffic. 85. Intent cannot be proven. Intent can definitely be proven. Anyway, I volunteered the information which is being misconstrued. The intent to use various payment methods which all funnel into the foundation was solely for ease of bookkeeping for federal tax reporting. The provider's technology was not sophisticated enough to list us as a nonprofit at the time of account opening. Since the December board meeting, I was able to get PayPal and Venmo to recognize the account as a nonprofit. There was a process in which the Venmo had to be verified through PayPal first. We did not open a PayPal account for a few years because their system was antiquated compared to the newly emerging technology. PayPal was more expensive and slower to deposit, so the owner created Venmo, which is owned by PayPal, by the way, to compete with the changing times. The PayPal application was less popular among donors. Because of that, Venmo and Cash App were literally invented to provide a faster, cheaper solution that would keep up with the competition of cryptocurrencies. I fumbled around very frustrated with Bank of America for 3 months trying to get them to be our online payment processor, but their tech was incapable of providing a viable point-of-sale solution. Gee, I wonder if it's because Bank of America finally recognized your name and said, no, we won't work with you anymore. I don't know. Let's see. So we had to open other accounts. Similar to how I had to open credit card debts in my personal name, or credit cards in my personal name because the nonprofit was not considered a business in the too big to fail banking system. Oh my God. Also, the business startups do not qualify for funding in the first 2 years, so we had to make a workaround. Plaintiff wants to see financial records that do not exist. Every penny apart from the transfer fees goes in the foundation's account, even cash minus 20%. I vowed to tithe on the streets to the homeless for starving artists. Counts 1 through 3, 87 to 90. I have disproven too many of the plaintiff's claims for the following counts to be upheld. There is no evidence beyond a reasonable doubt that I destroyed, mutilated, or concealed the property of the estate after the date of filing the petition. The paperwork for the Magic Money Miracles LLC, which I had forgotten about, as I have repeated several times, is in a drawer in a 300-pound solid wood desk in storage, wrapped up like a burrito, so the contents of the drawers would not fall out during transport. Its purpose was to create a proper separation of potential business activities that were not seen to fruition. Count 4, 91 to 95 says, unless such act or failure to act was justified under all circumstances of the case. I believe living in constant pain for 2 years while taking care of helpless, innocent newborn as a single mother justifies my failure to act. He's not even 2 years old. I believe the traumatic brain injury and inability to read or think straight should absolve me of any inconsistencies with the amended filings. So she thinks that because life happened, that she shouldn't be held accountable for anything. Her prayer, which is her final request, wherefore it be considered defendant prays for the following relief. On counts 1 through 4, defendant should be found not guilty. Defendant's case should be dropped. All of the debt has already been written off of the books. Plaintiff should not collect the bank Plaintiff should not collect off the backs of children and their mothers. I do not have time to keep repeating myself. Bring the judge forward and have him decide if he still cannot understand that it is 7 a.m. and I need to be asleep with this baby. It is already a kick in the pants enough that I chose to have the baby. It bankrupted me, caused me to become physically disabled with 7 herniated discs, scoliosis, fractured L4 and S1 sciatic nerve pains. And then I get a concussion, can't see clearly, and some stranger is trying to profit off of my failure. It's just rude and immoral, so please stop projecting this predator storyline to me. I have been transparent. And then she signs it, and then I chose to file this pro se because I could not afford a lawyer. I chose instead to pay back my student loan debt because the government gave me a reasonable path to do so. This shows in good faith my efforts to be responsible financially. God bless and earnest, Ellen Ring, real person, and then she signs it on April 3rd, 2023. So her baby is barely a year old. So she must be talking about pain during the pregnancy if she's going to claim 2 full years of that. And that was her response to the complaint. And while she was racking up debt in 2016, she was filing to get a driver's license back right here. See, 2016, living in Austin, Texas. She wants to have her license returned because it was suspended for reasons other than physical, mental, or disability or impairment. Yeah, that was happening. And let's see. Her lawsuit. Let's look at her lawsuit real quick. So this is from National Collegiate Master Student Loan Trust. And they've been trying to get her for a long time. Plaintiff seeks only monetary relief of $100,000 or less, including damages of any kind, penalties, costs. So Ellen Ring, defendant. This was filed in 2014. 2014. They want $100,000 for what she's owing them. And then this was another filing from the same case. They're trying to serve her. September 9, 2014. They're trying to serve her for this. Because she's back in America. She's finally back. They're trying to serve her. And then they're saying that it's Plaintiff National Collegiate Master Student Loan Trust. I hereby file this is notice of non-suit without prejudice as to the above cause of action asserted against Ellen Ring. So this can come back. All of this can come back. Non-prejudice means it can come back. Dismissed without prejudice as to refiling of same as to the above reference matter. Yeah, Ellen can totally see they couldn't stick it to her. This was in 2016. For some frickin' loans, they wanted $100,000. On this day came to be considered notice of non-suit without prejudice, filed by Plaintiff National Collegiate Master Student Loan Trust. The court, being advised plaintiff's non-suit, hereby orders that the above entitled and numbered cause be dismissed without prejudice as to refiling of same as to the above referenced matter asserted against defendant Ellen Ring, with all costs taxed to the party incurring same. So, for some reason they weren't able to nail her for it, but they also left it open. They left it just open enough. So all that is part of what Ellen is having to face right now. It's her lawsuit. That she only filed this year. She only filed this case file date. It was just before her mom died. Well into her bankruptcy. She knew she was suing. She was talking about suing on her OnlyFans and on her Instagram, and she's not talking about it in court. So there's 4 hours of me reading legal bullshit from Ellen. I'm probably going to regret this. But hi. I don't really like close-ups. But I'm a semi-public figure at this point. Not really public, but, you know, doing my thing. I'm online again. Ellen is one of the reasons why I stopped wanting to be on the internet. When I was a teenager, before I was 18, when I was building everything up for myself and I was being creative, I was like, cool, yeah, I can separate my life from the life I had at my dad's house where I lived with Ellen and the violence and the abuse. And that's part of why I lived online with this alias, Piper Moreau. It was great to have a pen name for when I started writing. And then it just sort of became something that I utilized on the internet because honestly, I never wanted to hear from her again. Once I got out of the house and had to stop answering the phone and hearing her voice, I felt so much relief. But I wanted to continue not using my legal name so that I could just be left the hell alone. The people who I went to high school with, they know how to contact me. They know what's going on. They know everything. My family is not really on social media, so we don't have to worry about the confusion of a nickname versus my real name. But watching Ellen lie so flippantly in court over and over again, and then tell the court that she's insulted that they're doing their job, like, I understand that she's not a successful cult leader. I am thankful that she's not a successful cult leader, but she wants to be one. There's more going on under the surface of this Carina Carinosa persona that Dave was saying in one of his videos that he was sitting outside of a studio where she was recording some kind of music, which means she's still doing this stuff. The foundation still exists, and she's still trying to make money off of her healing bots bullshit. I don't know how she's expecting to get out of this fraud against her mom. I don't know how she's expecting to get out of this bankruptcy fraud stuff that's going on. I actually feel a responsibility to let these people know that, hey, I've been around for some of this stuff. I got to witness some of the misappropriation for college loan funds. I am aware. And if all they need is for another person on this planet to say, hey, I'm aware, and I'm aware of her living situation. I used to live in the house. It was a private residence. She's claiming her business foundation on it. How can you claim your charity and all of this stuff to be your mom's residence? Like, how is she leaving out the fact that her mom is paying for all of this stuff that was in that house up until the day she died? I think it's important for her case. So I'm going to sit here in awkward silence and I'm going to wait for my video to appropriately end because I've been cutting off my stream like before my stream is done. Like, so I'm going to just go ahead and say thank you for tuning in. If you know anything, please comment. If you can share, please share. I haven't worked on the clips that I said I was going to work on because I've been doing so much fucking reading. I have a lot of making up to do and I'm sorry. It is my fault. I've been not sorting how I want to do stuff and then I have been sleeping a lot because of some health issues. So there's that. Try and balance it. New to doing this internet stuff like the way that I'm doing it. So I thank you for your appreciation. I thank you for hanging out. Please take care of yourselves. Please don't let people emotionally abuse you. I know that there are people on this planet who are going to be emotionally abusive, so it's like impossible to completely avoid experiencing it. But if you can stand up against it, please do. for yourself or for others. The one and only thing that Ellen says in all of her bullshit that is true is it doesn't serve you to be small. But she said it in an abusive way, and I am saying it in an empowering way. I think that within all of us is an entire person, and we matter. And maybe some people are into some bad stuff, and that's not great for society. And we, as a community, need to decide how to handle that. But then outside of those people with actual negative intentions, there's everyone else. There's just us. Being us with our interests and our things, and we're not trying to hurt anybody. And maybe we don't all get along, we don't have to, but we don't have to be shitty. And we don't have to beat up old ladies. And we don't have to lie about the health of little children to manipulate people. We don't have to forge documents like that. We don't have to steal. We don't have to steal from multiple stroke victims. And it's a really good thing to stand up against that sort of stuff. And it's really good to have a voice that says, no, you can't do that to people. And we will not let you continue to do that to people. One victim is too many. And so with that, I'm going to do my thing that I'm going to wait to see on the screen. And after I see it on the screen, I'm going to end the stream. So if there's some weird sitting here-ness for you, I'm so sorry. It's definitely going to be weird sitting here-ness for me. Cheers.